effort in Ohio for us and was part of Lawyers for Bush. Mr. Melman wrote, quote, "He is a true loyalist." Now, again, being politically active or a loyal Republican are not disqualifying characteristics for a Supreme Court nominee, not in my book anyway. But let's think back to the 2004 election. Let's look at Ohio, where you volunteered. Ohio is one of 11 states in 2004 where Republicans working to support the re-election campaign also worked to put anti-gay marriage amendments on the ballot. These state constitutional amendments passed, all 11 of them. The text varied state by state, but generally the amendments define marriage as being between a man and a woman. The amendments sent a clear message to lesbian and gay couples that their unions were not equal in the eyes of the law. Now, you were a campaign worker in Ohio. You'll remember the group Lawyers for Bush Cheney. As a lawyer and as a student of the Constitution, how did you feel about the right to marry being put to a popular vote?
Senator, I don't recall any involvement in that issue during that campaign. I remember going to Ohio.
Were you aware of that issue at all?
Oh, certainly I was aware of it.
And how did you feel about it?
Senator, my personal views, any revelation of my personal views about this matter would indicate to people how I might rule as a judge, mistakenly, but it might. Okay. And I have to be concerned about that.
These discriminatory amendments were part of a deliberative effort to drive up the turnout, and we know that because your friend Ken Melman said so. Mr. Melman was interviewed by The Atlantic in 2010 and said that the Bush campaign had, quote, been working with the Republicans to make sure that anti-gay initiatives and referenda would appear on November ballots in 2004 and 2006 to help Republicans. Now, to be clear, there's nothing to suggest that you were involved in crafting that strategy, but at the time, this tactic received a lot of attention, including in Ohio, where you worked on the campaign. There's a profound impact on people's lives. But a lot has changed. Since 2004, Mr. Melman announced publicly that he is gay, for one. He also voiced regret about what happened. He apologized. He said, "At a personal level, I wish I had spoken out against the effort. As I've been involved in the fight for marriage equality, one of the things I've learned is how many people were harmed by the campaigns in which I was involved. I apologize to them and tell them I'm sorry." That's a brave thing to say. It's hard to admit regret. Mr. Melman had a personal connection to the issue, to be sure, but our country has come a long way in a relatively short amount of time. A lot of folks have changed their view about marriage equalities, Republicans and Democrats alike. In the meantime, Supreme Court has settled this issue. Marriage equality is now the law of the land, so you shouldn't have any problem answering this question. How have your views of marriage equality changed, if at all, since the 2004 election?
Senator, my personal views, if I were to begin speaking about my personal views on this subject, which every American has views on, would send a misleading signal to the American people that my
It's settled law.
It is absolutely settled law. There's ongoing litigation about its impact and its application right now. And I cannot begin to share my personal views without suggesting mistakenly to
Okay,
people.
can I move on to something else?
Well, if I might
Thank
finish,
you. I understand. You've given a version of this answer before, so I understand. I'd like to return to something I raised in my opening statement, and that's your view of administrative law. Standing before conservative activists gathered at CPAC, the Conservative Political Action Committee, President Trump's chief strategist, Steve Bannon, and his White House chief of staff, Reince Priebus, outlined the president's agenda. Two topics were featured prominently: deregulation and your nomination. Now, I don't think that's a coincidence. Reince Priebus started by explaining why nominating you was so important for the president to do right out of the gate. He said, referring to your nomination, quote, "Number one, we're not talking about a change over a 4-year period. We're talking about a change of potentially 40 years of law, number one." That's change of potentially 40 years of law. Change the law. You and your colleagues here have said the job of a judge is to follow the law, even if he dislikes the results. You said that, not change the law or change 40 years of the law. but that's what Reince Priebus said this is about. When the White House Chief of Staff is talking to his friends at CPAC, he says a justice's job, that your job is to change 40 years of law. Yet my colleagues and you say it's to follow the laws as written. Well, it can't be both. So which is it?
Senator, it's to be a judge, to be fair, to follow the law, to apply it to the facts and circumstances of each case, and to live out my judicial oath on whichever court I serve on, whether it's the 10th Circuit, where I've served for the last 10 years.
Okay.
And where my opinions have been unanimous 97% of the time, Senator. I've been in
I understand. And again, you've given many times that answer, so if you'll indulge me. Mr. Priebus went on to say your nomination was central to President Trump fulfilling his policy objectives. Quote, Neil Gorsuch represents the type of judge that has the vision of Donald Trump, and it, referring to your nomination, fulfills the promise that he made to all of you, speaking to the conservative activists gathered at CPAC. What do you think that Mr. Priebus was talking about? Was he suggesting that if confirmed, you would be positioned to shape the court's decisions for the next 40 years, or was he suggesting you could reach back 40 years? Roe v. Wade turned 44 this year, and the president has promised to nominate judges who would overturn Roe. Chevron is 33 years old. I think this is a legitimate question. Was Mr. Priebus suggesting that you go back and change 40 years or of settled law or have an effect on the law moving forward?
Respectfully, Senator, Mr. Priebus doesn't speak for me, and I don't speak for him. I don't appreciate it when people characterize me, as I'm sure you don't appreciate it when people characterize you. I like to speak for myself. I am a judge. I am my own man.
Okay, I just want to we've had some talk about this. I don't think we're crazy to think that the administration and Reince Priebus, I don't think he was lying. And are you comfortable with your nomination being described in such transactional terms?
Senator, there's a lot about this process I'm uncomfortable with. A lot. But I'm not God. No one asked me to fix it. I'm here as a witness, trying to faithfully answer your questions as best I can, consistent with the constraints I have as a sitting judge. Here to answer questions about my qualifications and my record.
I got it. Well, I find it unsettling that the administration is talking about, the chief of staff is talking about the Supreme Court that way. But I want to get back to the panel at CPAC. After Mr. Priebus discussed your nomination, Steve Bannon talked about the president's agenda. He described 3 priorities, and one of them was, quote, the deconstruction of the administrative state. Now, here's what Mr. Bannon meant by that. He said that regulation was a problem from his perspective. Quote, every business leader we've had in is saying not just taxes, but it is also regulation. He said that if you look at the president's appointees, quote, they were selected for a reason, and that is deconstruction. The way the progressive left runs is if they can't get it passed, they're just going to put in some sort of regulation in an agency. That's all going to be it's all gonna be deconstructed. Taking Steve Bannon at his word, do you think only cabinet appointees were selected to bring about this deconstruction? Or do you think the White House also sees a role here for its judicial nominees?
Senator, respectfully, I believe that's a question best directed to Mr. Bannon.
He's not here. I'm just quoting him, that's all. I think the White House does see judges as a part of this deconstruction. I think that they're seeing your nomination as an important step toward achieving this goal. You've shown a willingness to disregard agencies' interpretations of statutes. You did that in Trans Am trucking with the Department of Labor regulation, for example. You've done in other cases as well. And in August, you wrote that concurrence to your own unanimous opinion in which you described Chevron, the Supreme Court's landmark administrative law case, as, quote, permitting executive bureaucracies to swallow huge amounts of core judicial and legislative power. You wrote, quote, maybe the time has come to face the behemoth. Now, generally speaking, as we've discussed, Chevron provides the courts should defer to an agency's interpretation of the federal laws that it is tasked with administering. When Congress passes laws that require agencies to implement them, say by issuing safety standards for children's toys or rules that ensure that pharmaceuticals or medicines are safe, those agencies turn to experts to develop those policies. Experts like scientists at the FDA, for example. I think that's a good thing. We want experts doing the work. What we senators don't want to be doing is deciding how much lead can be in your water or what the distance in the slats are in a baby's crib. I don't trust Senator Coons to do that. Chevron provides that when agencies do that, courts should be wary of stepping in to overrule them without a good reason. This is Scalia's agrees with Chevron. But I'm concerned that this administration sees common sense health and safety rules as a burden on big business. And I'm concerned that they want to appoint pro-corporate judges who are willing to substitute their own judgment on these matters for those of experts. Do you believe that Chevron was wrongly decided?
Senator, I'm a circuit judge. I don't tell my bosses what to do. I do, when I see a problem, raise my hand and tell my bosses I see an issue here. And I did in that case, not because of any big corporate interest, but because of what happened to Mr. Gutierrez, an undocumented immigrant to this country, and the whipsaw that he was placed in by a change in law affected by an administrative agency, a bureaucracy, overruling a judicial precedent and telling him he now had to wait not 10 years out of the country, but 14, something like that. And, Senator, that's part of my job to say these things when I see problems like that. It's a due process problem I saw, and no one, Senator, is suggesting that scientists shouldn't get deference or chemists or biologists. Section 706 of the APA is quite clear that on facts,
So you want to address this behemoth, and that suggests that the comments made by Mr. Priebus and Mr. Bannon know exactly what you think about these issues. And I think some of my colleagues on the other side of the aisle do as well. This is a big deal. During the entire 114th Congress, Chevron deference was mentioned only twice on the Senate floor, but between the announcement of your nomination on January 31st and last week, that decision was mentioned 30 times by 4 different senators. Each of those 4 senators discussed the case while speaking in support of your nomination. 3 of those senators are members of this committee. So I know you're choosing your words very carefully, and I know you're trying not to signal how you might rule in certain cases, but I think some of those signals have already been sent. Thank you.
Senator Sass.
Thank you, Mr. Chairman. Judge, you mentioned that there are a number of things about this that have been disappointing to you in the process. I'm disappointed in Senator Cruz, partly because he stole a lot of my originalism plan of questioning, but also because he went to mutton busting. I was convinced that I was the only guy that had mutton busting in today's pool. So my wife also sent me a text a little bit ago and said, and I'm sure she didn't expect me to read it, but how in the world is Gorsuch able to go so many hours at a time without peeing? I won't make you answer, but the SCOTUS bladder is something the whole country stands in awe of. So you're over halfway through your 11 hours today, so congratulations. Judge, let's do biography for just a second. You're a father. Remind me the ages of your children.
Boy, I don't even know what to say now.
You really caught me off guard there, Senator Sass.
Welcome.
My daughters are 17 and 15.
Okay. So besides fishing, have they ever played sports?
Oh, my goodness. Yes.
Have you ever gotten to a Little League game early, pulled the umpire aside in the parking lot, and asked him or her to commit in advance that they will decide the games for the underdog?
No, but I think some of my buddies have.
Have you ever asked a referee underneath the zebra stripes of their jersey to wear your kid's Little League jersey as the undershirt below the
No, and it wouldn't
referee's
have helped any. My kids were pretty rotten at basketball.
We're obviously not going to pursue this very far, but I do want to make sure that everybody at home knows a little bit of what's been happening in the room over the course of the last 6 or 7 hours. Because some of my colleagues are asking a bunch of tough questions that are really important for you to have to answer. At the same time, there are a whole bunch of questions that have been asked today that are really asking you to take your legal career and your legal ethics and set them aside and play politician on TV today. And that really isn't your job, and some of this questioning really hasn't been a fruitful use of our time. It's well-meaning to talk about the outcome objectives of a whole bunch of these cases, but I would submit that it's dead wrong. I want to give you just a couple of the questions we've heard earlier today. At different times, how can we have confidence that you won't be for the big guy? At another point, how can we know that you feel for the little guy? This sounds noble, but it's fundamentally a corruption of what the judge's job is. To seek assurances from you like this is like seeking assurances from a referee before the game that they will pledge to a certain outcome before the tip-off. If the law is wrong, and I'm somebody who believes that lots of our laws are wrong and overreaching around here, the question should be directed back at us on this panel and on this dais why we don't fix the laws that are wrong. We shouldn't be asking you as the judge to commit that when our laws are clunky and bad and in conflict, you will divine how to change the law on the fly. That's not the oath that you'll take. That's not the Constitution that we've all taken an oath to and pledged to. And it's not what the American people want. So, frankly, I applaud you for your perseverance and patience with us as we've continually gone down a path of asking you to answer questions, many of which are fundamentally political questions and that you shouldn't be answering and that we shouldn't be asking. So thank you for your endurance. I'd like to go back to something that's a little more productive for the committee and, frankly, I think productive for the moms and dads at home. And I'd like to talk a little bit more about the judge's robe. We both spoke about it yesterday, I would note, with no coordination. It turns out we've both just read your stuff from the past. And the judge's black robe reminds us of the meaning of your job. It reminds the plaintiffs that stand before the court. It reminds the judge as he or she dresses in the morning, and it reminds our kids, or it gives us an opportunity to teach our kids. And you've spoken eloquently about it in the past, but I think it's fitting for you to unpack it a little bit more in light of some of today's questioning. Earlier today, you were implored to tell us a little bit more about what is in your heart. And I think that's fundamentally a confusing question for us to be asking of a judge, except insofar as we would ask you, are you a man of your word who, when you take an oath in your heart, are pledging to keep your word and to keep your oath? And I think we all know that the answer to that question is yes, and it's why you're going to be confirmed, because people believe you to be a good and fair-minded judge. But every American, in a more fundamental way, needs to know what's in the heart of legislators, because we are supposed to speak for the hearts and minds and hopes and dreams of 320 million American people. We are supposed to cast a vision for the country, those things we want to conserve and preserve, and those things that we should argue about and change. We are the ones who are supposed to weigh the pros and cons of various legislative options that are available to us. Judges, on the other hand, are supposed to be following the law impartially. Your heart is supposed to be inclined neither toward the rich, nor toward the poor, nor toward black, nor white, nor people with big bank balances or small bank balances, but your heart is supposed to be your commitment to the law as you find it. So let's engage in a little thought experiment. 30 or 40 years from now, when you retire and hang up your robe and you're out fishing or sitting on the front porch of your surely lovely home, and you look back over your career, how will you know if you were a good judge?
Senator, that's a question I ask my kids every semester. when I teach ethics finish the semester with asking them to spend 5 minutes writing their obituary. They hate it. They think it's corny. I might be a little corny. And then I ask them if they'll volunteer to read some of them. And people want to be remembered for the kindnesses they showed other people by and large. And what I point out to them, what I try to point out is it's not how big your bank account balance is. Nobody ever puts that in their draft obituary, or that they billed the most hours, or that they won the most cases. It's how they treated other people along the way. And for me, it's the words I read yesterday from Increase Sumner's tombstone. And that means as a person, I'd like to be remembered as a good dad, a good husband, kind and mild in private life, dignified and firm in public life. And I have no illusions that I'll be remembered for very long. None. If Byron White is as nearly forgotten as he is now, as he said he would be, I have no illusions. I won't last 5 minutes. That's as it should be. The great joy in life, Shaw said, is devoting yourself to a cause you deem mighty before you're thrown on the scrap heap. An independent judiciary in this country. I can carry that baton for as long as I can carry it. And I have no illusions I'm going to last as long as you suggest. And that'll be good enough for me.
Well said. And would it be that more who taught legal ethics and business ethics and medical ethics and theological ethics would assign their students the obituary challenge? We might live less in the soundbite culture and more in a way that thinks about service and duty and calling. It's a great assignment. Neither Cory Gardner nor Michael Bennett have to fear that you're going to challenge them for a Senate seat from Colorado in the future?
Senator, I admire them both, and I think it's a wonderful fact that they were both here to introduce me, and that they follow a tradition, the West, where Senator Salazar and Senator Allard, Republican, Democrat, introduced me last time around. And frankly, 10th Circuit nominations, thanks to, he's not here at the moment, but Senator Hatch cares about the 10th Circuit. Republican and Democrat generally go on very smoothly. And it shows. It shows that you all have picked, I don't know how it works. I don't know how this crazy process works. But the colleagues you've selected for me over the years are wonderful colleagues, wonderful people. And I've been richly blessed to spend 10 years with every one of them.
So when you distinguish between the rearview mirror of a justice later or a judge later in life looking back and the rearview mirror of a senator, we have different callings. And so I think, without putting words in your mouth, you're going to be able to say that you can be proud of your career even if you failed to advance your policy preferences in this calling. But unpack that for the American people. Help them understand how the retrospective look of a senator at her or his career is different than a judge's retrospective look.
I suspect, but I don't know, because I haven't sat where you sit, and I wouldn't presume to be able to walk in your shoes. But I presume, gingerly, that you will look back on your career and say, I accomplished this piece of legislation or that piece of legislation, and change the lives of the American people dramatically as a result. I was fortunate enough to serve as a page in this body many years ago. It's an experience every young person should have. It'll give them a lifelong love of this body. It is the greatest deliberative body in the world. I believe that even sitting here. A judge looking back, the most you can hope for is you've done fairness to each person who's come before you, decide their case on the facts and the law, and that you've just carried on the tradition of a neutral, impartial judiciary that each person can come to with some sense that they're going to receive a fair hearing for their disputes. That's what we do. We just resolve cases and controversies. And lawyers are supposed to be fierce advocates. And I was once a fierce advocate for my clients. But a judge is supposed to rule impartially, to listen courteously and rule impartially. So, frankly, my legacy should look and will look a lot smaller than yours. And that's the way the design of the Constitution works.
In an earlier line of questioning, you were asked about 2004 and the presidential election and your participation in it. I just want to clarify, you were not a judge in 2004.
Goodness, no. Correct. I was a private attorney.
And when you went onto the bench, what changed in your life?
Justice Jackson says, a robe changes a man, or it should. Now, I'm sure you would add woman today, too. A psychological change comes over that person. He was the fiercest possible advocate, Attorney General for FDR. And he wrote a dissent, as we've talked about earlier, in Korematsu. He wrote the steel seizures concurrence. It's a brave man. That's a judge's judge. Calling it like he sees it in each case as it comes, and writing clearly so that people can understand exactly what he's up to. And he's not hiding behind jargon, legalese, or 4 million footnotes. That's the best I can do on that.
Senator Cruz earlier asked you a series of questions about originalism, and I appreciated your, I'll probably paraphrase you inartfully, but you said you worry that the labels sometimes put us into boxes that eliminate the requirement or reduce the requirement we have to actually engage each other's ideas. So I won't pin you down hard on the term originalism, but many have critiqued originalism, including in some statements yesterday and today here, as backward focused or, quote, too rigid in adapting to our changing culture. Do you believe that originalism is just one judicial philosophy among many, or is it a description of what judges do?
I'm with Justice Kagan on this. I think it's what we all want to know. I don't know a judge who wouldn't want to know what the original understanding is of a particular term in the Constitution or a statute. That's information that would be valuable to any judge and considered by any judge. Again, in Heller, for example, Second Amendment case, deeply thoughtful opinions by both sides on that question. It doesn't necessarily decide the case, but it provides us a language to talk to one another in which we're trying to seek something outside of ourselves, outside of our own personal beliefs about what the Constitution or the statute at hand means. We're trying to do it in a way that's neutral and that we can say provides fair notice to those whose lives we're affecting, so that we're interpreting the law in a way that we can say they should have known. They were on notice. We're not putting a person in prison willy-nilly based on our preferences or taking away their liberty, but we're preserving it in accordance with the Constitution as it was written.
I'd like to talk a little bit about cultural catechesis or civics. As you and I have discussed in previous meetings, I'm of a view that we have a crisis. We are not passing on the meaning of America to the next generation. Something like 40% of Americans under age 35 tell pollsters that they think the First Amendment might be dangerous because you might use your freedom of speech to say something that would hurt somebody else's feelings. Actually, that's quite the point of America. Right, that there are all sorts of things people might differ about, they might want to argue about. Our founders came here and they didn't have the same views of heaven and hell and how you achieve salvation. And they came together and they forged out of the many one polity where we have a shared framework for ordered liberty, where we protect each other's rights, even to be wrong about fundamental things, wrong in our own views as we wrestle with these things. But we debate big and important questions in Washington, but more fundamentally in Boulder or in Fremont or Omaha, Nebraska. And you do it in the town square, and you do it at the church or the synagogue, you do it in the bar. And you fight about questions, but fight free from violence. And so we protect each other's rights to argue and to dissent. And we're not explaining that First Amendment to the next generation. And I believe that all three branches The legislative, executive, and judicial branches are led by people who are taking an oath to a constitution that's about limited government. It's about principled pluralism. It's about intentionally distinguished and divided powers. And I think all three branches have an obligation to do some of that teaching about civics. President Reagan, long before he was Republican president, before he was a Republican governor, when he was a Democratic labor union organizer, Ronald Reagan used to say, in any republic, you're always only one generation away from the extinction of freedom. If we don't pass along the meaning of America to the next generation, it means the next generation of our rulers aren't going to understand why we have this beautiful inheritance that we have in a constitutional system of limits. As a judge on the 10th Circuit, and soon to be as a justice on the Supreme Court, can you explain what you think your responsibilities and freedoms are to teach civics to the American people?
Senator, as a judge on the 10th Circuit, I've tried hard to do that, literally teaching class, speaking where I'm invited, when I'm invited, going to law schools, talking to students who visit the courthouse. And it's been a great privilege and a joy. I think here of Justice O'Connor, Sandra Day O'Connor. And when she retired, she did an awful lot of this. And she's done an amazing amount of work. And I do think that there is a need to remind people how to talk to one another, how we talk to one another, and more fundamentally about how brilliant the design of this Constitution is. Not perfect, but e pluribus unum from anyone. And we are all not Republican judges, Democrat judges, we're judges. And I think we do have an opportunity. And that's one of the things I look forward to as a justice. My little talks might be a little better attended on civics. And I hope to do that. And maybe that's a Western thing. I don't know, or Midwestern thing, Senator. But I really believe in this country, and I'm optimistic about its future. I see the young people, I teach them, I get law clerks. They really care about this country. And they give me hope every day. Senator Coons and I share the distinction of being Truman Scholars. And we go through the selection process of picking the next crop every year. Harry Truman didn't want a monument as a memorial here in Washington. Think about that. The humility of that. Instead, he wanted a living monument, a scholarship to young people who go on to do public service. Well, I've got two of them here. And every year when I go do that selection process, I don't know about Senator Coons, but it's one of the best days of the year for me because I see young people full of enthusiasm for this country and anxious to make it better. I look forward to working, if I'm so fortunate to be confirmed, on just this topic, Senator, with you, with Senator Coons, and anyone else.
Talk a little bit about the role of writing in the life of a justice. Justice Scalia was obviously a writer with a flourish. You've discussed having been tapped in the past to participate in speech writing. Talk about the purposes of both concurring dissents and traditional dissents, and what you think the objectives are at the appellate level, in your opinions, and is there a distinction when you're on SCOTUS?
When I sit down to write an opinion, people sometimes ask me who I'm writing for. I'm writing for myself. I'm trying to convince myself that I've got it right. And I go through a lot of drafts. And I sometimes, as my law clerks know, change tack as I'm drafting. I don't know how many drafts I've gone through on some opinions, but 30s, yeah, more.
He actually said 130, but whatever.
Because I'm trying to get it right. And I find I test ideas as I write. It's one thing to say to somebody else, oh, go write this up. It's another thing to have to sit down and write it yourself. and it exposes holes and gaps in your own thinking, causes you to question yourself, wonder whether you have it right. So for me, it's an exercise of getting it right and persuading myself at the end of the day, and writing in a language that persuades me. A lot of gobbledygook, and us lawyers are guilty of a lot of gobbledygook. That doesn't persuade me. I want to know through a clear line. I want to be able to see my argument from my topic sentences, and maybe it's Sister Rose Margaret, I don't know. But I want to see the argument flow. I want to see how it fits together, and then I want it torn apart by my law clerks who tell me I'm wrong. So it's an iterative process. So at the end of the day, that's what it's all about. And then it's about the test of my colleagues, and I take their comments very seriously. I believe in collegiality. I believe that 2 heads, 3 heads, 9 heads are better than 1. And so I think a good judge can't have too much pride of authorship, has to accept criticism, constructive criticism, and try and incorporate or deal with that criticism. Maybe that's why my opinions have attracted relatively few dissents. I don't know. But I take collegiality very seriously. As to writing separate opinions, I don't do it very often. And when I do it, it's usually because I'm just stuck. I might be wrong, but I'm just stuck. Something doesn't seem right to me. And I've tried to discuss it with my colleagues. I've tried to work it out. I bend as far as I can bend. But at the end of the day, I take the oath to follow the law where it leads me. And I try hard to reach a collegial consensus, but when I can't, I write up what I can as respectfully as I can, and usually in as few words as I can, a dissent or a separate concurrence. Sometimes, because it's fact-bound, but it's just where I'm stuck. Sometimes because I see an issue that my bosses need to be aware of. Like any good employee, hey boss, you might want to think about this one. Seems kind of tough to me. And I think that's part of the process of a good judge.
I'm a historian by background, and when I was writing my dissertation, to your audience question, one of my advisors just kept pounding me saying, I don't know who you're writing for here. It seems scattered all over the place. And he finally persuaded me to put a picture of my aunt on the farm next to my computer. And she's smarter than I am, but she knows nothing about my topic. And he said, if you recognize that your audience should be smarter than you, but ignorant of the subject matter, you're finally going to find your voice.
Yeah.
Is there something analogous in the writings of the Supreme Court where you're not just writing for other justices, but you have an obligation to write for the American people?
I think if you're sitting and writing your dissertation for yourself with your picture of your aunt, you're right on target, right? Because I think if I'm writing for myself and trying to persuade myself, then I figure everybody will be able to at least track what I did. Maybe not agree with every opinion, every single one of the 2,700 decisions I've issued, but they'll understand why I got where I got. I was candid about it. I didn't hide. I stood up. I was clear. I was honest. I was forthright. Plain spoken. And you can judge my opinions, for better or worse, on their merits. And I think that's what a good judge does, is candor, the duty of candor.
We finished voting a day early last week, and so a lot of us were back in our states traveling and doing town halls and Rotary clubs and schools. I ran into 3 different teachers who planned to use these hearings on C-SPAN to teach civics. I wonder if you could help those teachers explain, as one of them asked me, about why we have a Bill of Rights. To remind the American people, the Constitution's a negative document. It is not the government giving us freedoms. It is us giving the government a limited set of enumerated powers. And originally there was no Bill of Rights. And as a part of a compromise, we added one. Today, most people, when they think about our Constitution, think of the Bill of Rights first. Why do we have a Bill of Rights, and what fundamental difference would it make if we didn't have one?
That's a big question. For us adults?
The chairman said I could have an extra hour, so take your time.
Yeah, I've got 4 minutes and 19 seconds on that. That's a big question for us adults who are where we are. It's a big question for my middle school and high school age kids. The Constitution, as a negative document, the theory behind it, in short order, was to divide power, the better to protect liberty. That's the theory. That you put all power in one set of hands, you're going to get tyranny. And our founders had too much evidence of that in their own time. It's kind of a hard-won inheritance. Part Enlightenment theory, right? Part on the battlefield. They saw what it was like to have power amalgamated in one set of hands. Dangerous. So they divided it. They divided it three ways in our federal system. You, Article 1, write the laws. And it's tough. It's supposed to be tough to protect liberty. We don't just have one house, we have two houses. And then it has to be signed by the president, too. Really hard. Bicameralism and presentment is designed to make legislation difficult, the better to protect liberty. The president's powers are to execute the laws, not make them, not adjudicate disputes. Our role is to decide cases and controversies between the people under law as it is, not as we'd wish it to be. We're not legislators, we're judges. The legislative power is invested in this body. That's not all. Then we divide power in a way that was quite unique, well, unusual. Federalism. So you can think of separation of powers as having a horizontal access and a vertical access, so that the federal government has certain enumerated powers and authorities. And what the federal government doesn't enjoy, the states do, as sovereigns. This country as well, we have tribes, which also bear sovereignty in our part of the world and bear recognition as such. And I'm glad to have the opportunity to recognize that fact here as a Westerner. So we have the separation of powers between horizontally and vertically. And that wasn't thought enough to protect liberty. The drafters of the Constitution, many of them thought that that would be more than sufficient, that that in fact was the main way to preserve liberty. But our founders were very suspicious and very jealous of their liberties. So they added the Bill of Rights, and they enumerated 10 of them, as you know, starting with the freedom of speech, freedom of religion, no establishment of religion, right to bear arms, the Third Amendment, which I'm glad we don't litigate much. I wonder how many of the high school kids now watching know what the Third Amendment's about. Go look it up.
And get $20 out of your pocket at the same time.
So that's what the Bill of Rights is about, is ensuring not just these negative protections, but some positive affirmative guarantees against governmental encroachment.
Thank you. I want to ask a few more questions about the Bill of Rights, but I'll save it for my next round since we're at 40 seconds remaining. Thank you, sir.
Thank you. Thank you. Chairman Grassley, I'd like to ask unanimous consent to enter into the record a letter from 19 different faith-based and secular organizations expressing concerns about Judge Gorsuch's rulings on church and state and free exercise.
Without objection is centered.
Thank you. Good afternoon, Judge.
Hi, Senator. Good to see you.
It has been a very long and hopefully very informative and instructive day, and I'll suggest...
I was supposed to announce something. We won't take this away from your time, but I want everybody to be aware that after you get done, Senator Coons, we're going to take a 10-minute break.
Thank you, Mr. Chairman. The Third Amendment, some would suggest, was rooted in the Delaware Constitution. So although obscure, it is still beloved by some in the first state. Let's have a conversation, if we could, about religious free exercise and about liberty interest. There's an enduring tension or contest in our history between individual liberty and religious free exercise and the ability of government to enact and enforce neutral laws. And I want to better understand how you view the proper balance between these competing core values. And to that end, I found Hobby Lobby and your contribution to it concerning and interesting. The case centrally involves access to health care coverage, including contraception, for about 13,000 employees across 500 stores of Hobby Lobby and the religious views of the owners of that corporation. And you, Judge, joined the 10th Circuit majority opinion, holding that this for-profit business could, because of the business's religious beliefs, refuse to provide its employees with access to family planning. But you went even further than the majority, writing an additional concurring opinion emphasizing that the owners of Hobby Lobby, the Green family, were entitled to personally raise their religious objections, notwithstanding that they operated the business through trusts and corporations. In coming to that conclusion, you opened your opinion by writing, and I quote, "All of us face the problem of complicity. All of us must answer for ourselves, whether and to what degree we are willing to be involved in the wrongdoing of others." Complicity is not a concept I've seen widely discussed in free exercise jurisprudence. Why did you choose to lead your opinion with this concept of complicity, and what's it mean as we're trying to assess free exercise rights?
So under the religious freedom, Senator, thank you. Interesting, good question. I mean, this is what it's all about. The Religious Freedom Restoration Act protects this exercise of sincerely held religious beliefs and affords them the highest protection known in American law, strict scrutiny. That's a law that this Congress passed because it wasn't satisfied with the degree of protection that the Supreme Court was affording the exercise of religious liberty under the First Amendment. Under Smith, this Congress found Smith, written by Justice Scalia, to be insufficiently protective of the right to free exercise.
If you could, Judge, help me with your choice of the term complicity, which doesn't appear in that statute and hadn't previously appeared in free exercise jurisprudence.
Thank you for prodding me along. The point is, what's a sincerely held religious belief? The individuals there were devout Christians, and as they interpreted their religion, it was a violation, a sin, for them to participate in any way, in signing papers even, to allow the provision of certain contraceptive devices, those that they believed had the effect of destroying a fertilized egg.
Right. And
they were
that's
okay.
exactly, excuse me, Judge, but that's exactly why the question of your use of this term complicity is so interesting to me, is that it opens up a very broad, very attenuated, very remote connection between sincerely held religious beliefs by this devout family through a trust, through a corporation, a for-profit corporation, to impact the choices and life decisions of 13,000 people. It's a truly unprecedented decision. If I could just quote for a moment what I suspect is familiar to you, the dissent of the Chief Judge in your circuit, Briscoe. She said this opinion was nothing short of a radical revision of First Amendment law, as well as the law of corporations, wholly unsupported by the language of the Free Exercise Clause or the Supreme Court's previous free exercise jurisprudence. She claimed, Judge Briscoe, that there was literally no support for the proposition that for-profit corporations enjoy free exercise rights in the Supreme Court's previous jurisprudence. And I'm struck by the extent to which the use of the term complicity and your description of a substantial burden on a sincerely held religious belief opens possibly floodgates for litigation on behalf of those who have sincerely held religious beliefs. As you mentioned, the issue here was access to family planning. There were more than 20 forms of contraception that could potentially be covered. There were only a handful, I think 4, that the Greens objected to.
Right.
How far does this new concept, this newly injected concept of complicity go?
Senator, it's not a new concept at all with respect, because in enacting RFRA, Congress revived some older free exercise case law.
That's right.
Much of it written by Justice Brennan. Thomas would be a leading example, involving, I believe it was a Jehovah's Witness.
Yes.
Okay. Who was okay in producing certain goods that could be used as armaments, but not others.
Right.
Complicity in war making was a matter of faith.
The key distinction, if I could, Your Honor, between Thomas and this was that in that case, here's an individual whose deeply held religious belief made him say, I can't make turrets for tanks.
Right.
So the question is uniformly applicable law, unemployment insurance, Can he benefit? Fine. But it doesn't in any way implicate others' liberty interests. The core concern with the choice to recognize a very large, multi-billion-dollar nationwide for-profit company and to privilege the religious interests of its owners through the legal fiction of a for-profit corporation is it impacts 13,000 individuals. That wasn't the case in Thomas.
Senator, respectfully, I think we're mixing apples and oranges, because the first consideration is whether we have a substantial burden on a sincerely held religious belief. Mm-hmm. The second is whether the government has a compelling interest narrowly tailored to override it. Right. And I think we're mixing apples and oranges, because on the first one, complicity is very much in play. And it's the same in Thomas as it is with the Greens. How far does my religious faith, your religious faith, permit us to engage in things that our religion teaches are wrong, sinful? That's a matter of religious faith. And in fact, I don't recall anyone doubting or the government disputing that the Greens' religious faith was sincerely held on this score. So I think it's a given. So this complicity discussion, I think, frankly, Senator, is a red herring to mix my metaphors, because everyone accepted it.
We've got apples, oranges, and red herrings.
I know I'm mixing.
I
know it's terrible. I wouldn't want to write it down in an opinion. It's terrible.
Well, let me take, if I could, let me take you to a number of things, because several other senators have referenced Hobby Lobby. One of the things that Judge Briscoe was saying was sort of category shattering or precedent setting was the extension to a for-profit corporation. The recognition of a for-profit corporation that sells crafts and hobby materials as being a religious corporation. Previously, only incorporated churches or synagogues or associations explicitly nonprofit religiously affiliated organizations have been recognized. In the interpretation of RFRA, you choose to define person to include for-profit corporations. Help me with why you made that move.
Be delighted to, Senator, and thank you for the opportunity. I think I'd point to a couple of things. First, RFRA is a statute, and it uses the term person, and it doesn't define the term person. And when Congress doesn't offer us a specific definition, we go to the Dictionary Act, which Congress has passed for just these circumstances. And there it says persons include corporations. That's the law, as Congress wrote it. And if Congress wishes to change the law and say only natural persons enjoy the rights of RFRA, I'm a judge. I follow the law. But the law, as drafted, doesn't distinguish between natural persons and corporations. It includes them both. And the government, Senator, if I might just finish, conceded, as I recall, and my recollection may or may not be great on this, but as I recall, conceded that nonprofit corporations can exercise religion.
That's right. And that's exactly why this was seen as such a departure. There was a long settled expectation that religious free exercise rights adhered to individuals, living, breathing people, and to nonprofit corporations. It was a big leap for it to, for the first time, apply to for-profit corporations. And I appreciate that the opinion of the majority in your concurrence referenced the Dictionary Act. But the Dictionary Act actually says, on its own terms, that it applies unless the context indicates otherwise.
Right.
And the reality is, as I think one of the dissents points out, all Congress was intending to do, as expressed by a number of members of Congress, was to simply restore strict scrutiny, not to open up a whole new line of free exercise rights for for-profit corporations. So I think the context clearly indicated otherwise. And to simply say, all I did was pull a dictionary off the shelf, look it up, person can include corporations, we're done with the analysis, is in some ways tendentious, because the idea that a for-profit corporation could have religious free exercise rights was nowhere in the earlier case law that Congress explicitly intended to be the narrow purpose of RFRA. So does Congress's intent when it passes a statute, its clearly stated intent, have any relevance to your interpretation, especially where something like the Dictionary Act actually urges you to look at the context?
Senator, I'll offer you two thoughts on that. First, as I recall, sitting here, and I have to go study my books, but the Supreme Court in an earlier First Amendment case did recognize a challenge by an Orthodox Jewish shopkeeper to Sunday closing laws.
That's right.
That was a corporation, for profit. So respectfully, I'm not sure it's accurate to say there's no precedent for it. Second, I would say to you, the position you're advocating is a fine position, respectable position. It's a good position. It was adopted by precisely 2 justices of the Supreme Court, and only 2.
So the question I want to ask you now is, at what point, given this newly adopted, fairly broad interpretive standard, when do we stop deferring to an employer's religious beliefs when they conflict with generally applicable laws of neutral meaning? When do we allow the right of one to implicate the others? I think it was Justice Holmes who was attributed to have said that your right to swing your arm stops at the end of my nose. And part of what I think made Hobby Lobby striking to so many was that the choices of 13,000 individuals about their method of family planning were overridden by the sincerely held religious beliefs of a very successful family. So I'm looking for how you find a limiting principle in this new field. What's the limiting principle now?
Senator, respectfully, I don't believe that's accurate either, because all the court held was that the government had to come up with another alternative to provide the contraceptive care it wished to provide. The court acknowledged, the Supreme Court acknowledged that there was a compelling interest in providing the contraceptive care, and simply said that an accommodation could be reached that didn't involve the Greens or require them to give up their sincerely held religious belief, much as had been done for churches
That's right.
and hospitals and lots of other entities. And the government couldn't explain why it couldn't accommodate other entities like Hobby Lobby
That's
as
right.
well, or Little Sisters of the Poor.
But if I might just briefly, Judge, strikingly to me, in the 10th Circuit opinion in which you participated, you didn't recognize as a compelling interest gender equity in providing health insurance to millions. The Supreme Court did. They balanced these equities differently. Why didn't you think that that was a compelling interest to provide access to health care for millions?
Senator, I think it was just a matter of what the record was in that particular case before us.
That's also a striking point for me. This was a preliminary injunction. It's a significant, groundbreaking opinion where one of your colleagues, one of the other 10th Circuit judges, said we really shouldn't be deciding something of this import on a PI. We ought to be remanding to develop the facts below. The facts weren't really well explored. And the larger point I'm trying to make is that I think this could lead to some very troubling applications. So let's just take a minute and look at a few of the contours of what this, I think, precedent-setting decision might mean. So let's imagine the Greens were from a different religious perspective. If they were Scientologists, for example, who reject the use of antidepressants, or Jehovah's Witnesses who reject the use of blood transfusions, or Christian Scientists who reject really modern medicine largely altogether, could their sincerely held religious beliefs as Scientologists or Jehovah's Witnesses or Christian Scientists lead to the conclusion that 13,000 employees could reasonably be denied access to antidepressants or to blood transfusions or to health care whatsoever?
No, Senator, not necessarily. It doesn't mean that at all. All it means is that the government, under the law as passed by this Congress, with overwhelming bipartisan support at the time.
Well, the ACA was not passed with overwhelming bipartisan support.
I'm sorry, I'm speaking of RFRA.
Right. The accommodation is in the ACA.
Oh, and the ACA, you can override RFRA anytime you want. Congress could say RFRA doesn't apply to the ACA. That's another alternative. So you can abandon RFRA. You can say it doesn't apply to this particular statute. You can say it applies only to natural persons. You can say it doesn't apply to contraceptive care. Congress controls this decision, Senator.
That's right.
It's your decision. It's not mine, with all respect. We're just trying to implement what you've asked us to do.
So,
and Senator, on your hypotheticals,
yes.
Okay, Justice Brennan wrote these First Amendment cases that you were seeking to revive. I'd remind you of that.
Yeah.
All right? Justice Brennan. All right? And the fact of the matter is, sometimes the government can prove a compelling interest and that it's got the most narrowly tailored way to get there. And sometimes it can't. And each case has to be taken on its facts in the particular context in which it arises.
Well, then help me walk through, if you would, given we already know how you draw the compelling interest line in this particular instance of access to family planning or contraception. How else might you weigh these equities or draw these lines? If the Greens, for example, in Hobby Lobby, knew that several of their employees would spend their paychecks on other things they might say were immoral, like gambling or prostitution, could they refuse to endorse their paychecks?
Senator, it would go back to, we do the analysis,
Right.
the same analysis. Do they have a sincerely held religious belief? Sometimes people don't. I've had claims, for example, of individuals.
But in this instance, wouldn't you agree that their sense of the complicity that you referenced in your opinion would likely apply?
It depends.
Even though it's very attenuated.
Oh, no,
the choice of their employee to spend their money in a way they disapprove, isn't that different from the choice of the employee to choose among 24 forms of contraception, one of which they strongly disapprove?
Senator, I think it depends on the facts of the case. So, for example, I've had a case where a number of people came before us and said, we have a sincerely held religious belief that marijuana is God. Okay. It turned out it was a drug distribution ring.
Right.
All right. And what they really worshipped was the almighty dollar.
Many of us have teenagers at home watching.
Right. Well, and they were really just trying to make a buck. Okay. And the district court found that that wasn't a sincerely held religious belief. So that you can get off the train there. That's one place where you may get off the train in your hypothetical. You got another place you can get off the train. Is it a substantial burden?
Right.
Another place is compelling interest by the government. Another place is narrowly tailoring. So there are 4 steps in the process, and you have to go through all 4 of them as a good judge with the facts of each case as it comes. And, Senator, again, it's all statutory. You could abolish it tomorrow.
Well, let's take an example that I think was central to a lot of this analysis, United States versus Lee. It's an older case, 1982. It was a unanimous case. It's one where an Amish businessman declines to pay for Social Security taxes,
right.
Not just for himself, but for a few of his employees. And the court rejected his claim because the restriction on religious freedom, in their view, unanimously, was essential to accomplish an overriding governmental interest. Is Lee still good law?
I think Lee would be the sort of law you look at when you're applying RFRA, absolutely.
Because RFRA simply restored the strict scrutiny standard that Lee was decided under.
The Religious Freedom Restoration Act, exactly. So that's a very good example, Senator, of where the government was able to prove compelling interest in narrow tailoring. Yes.
Because the ability to have a Social Security scheme nationally that is sustainable is a compelling interest.
Yes.
But a nationwide plan to provide access to health care isn't.
No, Senator. Again, I think we're mixing our apples and our oranges because the government in the ACA was spotted the compelling interest. The problem was the narrow tailoring. You could get there without forcing the Greens to do something their religion prohibited. So it wasn't like the system of Social Security, which depends upon everyone's participation. That was a distinction the Supreme Court drew.
Let me just quote, if I could, Justice Scalia, who addressed this same issue in Employment Division v. Smith, and who said, it's precisely because we're a cosmopolitan nation made up of people of every conceivable religious preference, and precisely because we value religious divergence, that we cannot afford the luxury of deeming presumptively invalid as applied to the religious objector every regulation of conduct that doesn't protect an interest of the highest order. Now, obviously, the law's changed in terms of the review standard, but do we, because of Hobby Lobby, now have to deem every law to be presumptively invalid if it offends any conceivable religious preference?
Under the Religious Freedom Restoration Act, it's a 4-part test, effectively.
Right.
All right? And for every challenge, you ask those questions. Is there a sincerely held religious belief? Is there a substantial burden on it? If check, then you go to the government side of the ledger. Do they have a compelling interest? And is it narrowly tailored? And that's the law you've set forth, Senator, because this body didn't like, frankly, Justice Scalia's decision in Smith. And if this court, if this, the old trial lawyer in me, sorry, getting tired. If this Congress wishes to say Justice Scalia was right in Smith and we've changed our minds, that's entirely up to this Congress.
Well, I'm going to move on to another line of questioning, but I just want to say that one of the challenges I face in a couple of different gates through the analysis as laid out was how you decided to interpret the underlying RFRA statute, how it was extended to for-profit corporations, how the balance was struck between what I think are the mediating decisions of thousands of individuals versus the free exercise of the Greens. You've talked about being a Westerner. You've, I think, entertained us with mutton busting, something I haven't seen yet, and clearly I should. And I'm interested.
I recommend it.
I'm interested in your view of privacy and the autonomy of adults to make their decisions. It was, in fact, I think Justice Scalia who said there isn't a genuine Westerner on the court and that California doesn't count. As I shared with you, some of my extended family was from the West, and I think of Westerners as steadfastly independent folks. Justice Douglas, a famously Western justice, once said, "The right to be let alone is the beginning of all freedom." So in 2006, you authored a book, The Future of Assisted Suicide and Euthanasia, a topic of intense personal interest to many. And when reviewing your book, I was expecting you to conclude that people have the right to be let alone, because I think of that as an inherently Western trait, to make important and difficult personal decisions without the interference of government, but you didn't. Instead, you expressed a belief in the inviolability of human life. What did you mean by that?
Senator, respectfully, I'm not sure I'd agree with your characterization.
Of the book or of being a Westerner?
Of the book. I agree with your characterization of being a Westerner. The book does conclude that Cruzan is absolutely correct, that there is a right to be left alone at the end of life. These are hard decisions. I don't pretend to have any perfect answers here. I was writing this book, it was my dissertation, trying to contribute to what I thought was a very hard question. I still think a very hard question, one we all have had personal struggles with, Senator, as I know you have and I have. And this is a human problem. We're mortal. Cruzan held that people have a right to be left alone, presumptively, under the common law, presumptively constitutionally. To stop care, go home, die in your own bed, as a lot of my family members have done. The question is whether you should also have an additional right to have someone kill you, involve doctors in killing. And there are good arguments on both sides of that ledger, as I explore in the book.
Well, if I can, Judge, I'd like to help walk through that exploration of what you looked at in the book. And I think the Cruzan decision is a very important one. Because essentially the tension here is between whether there's a right for a conscious terminally ill adult to end their own life by refusing life-saving hydration and nutrition, as the Supreme Court assumed in Cruzan, or with the help of a doctor. And a lot of this rests in whether there is a right to privacy. Do you believe the Constitution contains a right to privacy?
Yes, Senator, I do. Privacy is in a variety of places in the Constitution. The first and most obvious place, back to the Bill of Rights, is the Fourth Amendment, right? The right to be free from unreasonable searches and seizures in your homes, papers, and effects. That's privacy, right? The Third Amendment, which I alluded to but didn't want to reveal.
Quartering of troops in home.
No quartering of troops. Stay out of my house with your troops. Now, happily, we don't litigate that much, right? The First Amendment, right? The right to free expression, which we've been talking about, and the freedom of religious belief, expression. That requires a place, privacy. And the 14th Amendment, Senator, over now about 80 or 90 years, the Supreme Court of the United States has held that the liberty prong of the Due Process Clause protects privacy in a variety of ways, having to do with child rearing and family decisions, going back to Myers, which involved parents who wished to have the freedom to teach their children German at a time it was unpopular in this country, and Pierce, the right of parents to send their children to a parochial school if they wish. So, Senator, yes, the Constitution definitely contains privacy rights.
One of the things that you say in your book, unequivocally, is that, and I think I quote, all human beings are intrinsically valuable, and the intentional taking of human life by private persons is always wrong. And I think that's a dividing line you draw between the facts in Cruzan and what has been proposed or adopted in states like Oregon. Can you point to any principle of constitutional law that says that, or has that principle, as you enunciated it, ever been offered by the Supreme Court or recognized by the Supreme Court?
Senator, I was speaking as a commentator before I became a judge, not expressing views as a judge, all right? My views as a commentator I'm happy to talk about, though. I found this a very difficult question. The Supreme Court has held that this is an issue for the states to decide under Glucksberg and Quill, for the people to decide on the state level. I agree with those decisions. I say so in the book. My concern about legalization that I express in the book as a commentator has to do with the equal protection principles we've been talking about today, the equal justice under law principles. And I am concerned, in the book, I express concerns as a commentator about what legalization might mean for the least amongst us, the most vulnerable, the disabled, the elderly, who might be pressured into accepting an early death because it's a cheaper option than more expensive hospice care, things like that that might cost more. And so that was a concern I expressed. Senator, I don't pretend, though, to have the last word on that or to know the right answer. I was contributing as a commentator to what I thought was a very hard discussion.
It is a very, very hard discussion, as you said, something that has an enormous impact on the terminally ill and their families.
Yes.
There was a case that I think was active at the time you were at the Department of Justice, where the U.S. Attorney General was suing Oregon to block their death with dignity law that permits, in that state, physician-assisted suicide. And in the documents you produced to this committee, you sent a message expressing hope that the federal government would win that particular case. Why did you want the federal government to win that case?
Well, I was an advocate for the government at the time, Senator. That's my job, all right? When you represent the government, you want the government to win. When you represent somebody against the government, you want the government to lose. And as a judge, Senator, it's a very different mindset.
And when you're up for consideration for the Supreme Court, it's important to know what you view as settled precedent. So let me, in my last 2 minutes, ask a question or two about that. In the Glucksberg case, which is about physician-assisted suicide, Justice Stevens said in his concurrence that avoiding intolerable pain and indignity of living one's final days incapacitated and in agony is certainly at the heart of the liberty to find one's own concept of existence, citing the Casey decision. What's your view of the application of Casey's mystery of human life language here?
Senator, the Supreme Court in Glucksberg, the majority held that this issue is for the states to decide and the people to decide. People of Oregon have made their decision to legalize it, for example. It was just legalized in November in my home state of Colorado. That's their right.
And how did you feel about that?
Senator, my personal views have nothing to do with my job as a judge.
Let me ask one last question, if I might. There was a line in your book that reminded me a great deal of Justice Scalia. You said that a libertarian principle legalizing physician-assisted suicide would require the government, inevitably, to allow sadomasochist killings, mass suicide pacts, duels, the sale of one's own life, not to mention illicit drugs, prostitution, the sale of one's organs. Help me understand, in closing, why finding a constitutional right to physician-assisted suicide would directly yield to this long list of other, perhaps more shocking, constitutional rights to prostitution or drug use or the sale of organs. Help me understand that leap.
Senator, in each chapter, I analyzed different potential arguments, one of which was this libertarian argument, and it applied faithfully to its end. It leads to where it leads, as some of the authors of the argument acknowledge. I'm not making it up. There are other arguments, though, that one might deploy that I analyze as well. That's not the only available argument for legalization by any means.
Thank you, Judge. Thank you, Mr. Chairman.
We'll recess for 10 minutes, so that'd be approximately 5:40. And then it'll be Senator Blake.
Do you need help with that?
Before,
I'm sorry. Never mind.
before I call on Senator Flake, this is how I would like to go forth for the rest of the evening. We have a vote scheduled at 6:10. That'll be about the time that Senator Flake will be finishing. I would like to have Senator Blumenthal would be the next one up. I would hope, Senator Blumenthal, you could go vote at 6:10 and be back here and take over, and I'll operate within that. And then I would like to suggest that I have asked Senator Tillis to take over about 8 o'clock so I can be in bed by 9 o'clock, because I get up at 4 in the morning and I want to be able to get a good night's sleep so I can run in the morning. And so you understand, Judge, that I'm not, I hope you'll understand why Tillis has taken over.
A little envious,
Okay.
Mr. Chairman.
Senator Flake.
Thank you, Mr. Chairman. Thank you. This is a long day. And I know what it feels like. It reminds me of being at the end of the table. I have 10 brothers and sisters. And getting there, and there's no more questions to ask. No more food left on the table either. But I appreciate your endurance here. And speaking of I have 10 siblings. I have 5 children as well. I don't know about my colleagues, but that's how I get elected. in Arizona, but it helps. Not so much for a judge, but for senators it does. And just like Ben's family, my family's been texting me throughout this process, asking me to ask questions that they would ask. I asked a few of them, for suggestions, and my son Dallin, a teenager, said, ask him if he would rather fight 100 duck-sized horses or one horse-sized duck. I'd never heard it either. Apparently it was a question on Reddit a while ago, but anyway, that's where it's going from here, I think.
You can tell him I'm very rarely at a loss for words.
Okay, all right.
But you got me.
I will tell him a teenager stumped you there. My brother Scott asked if you've ever worn gym shorts and a tank top under your robe.
Senator, on that one, we have what's called the Fifth Amendment, which is part of the Bill of Rights as well, and which, of course, protects the right not to self-incriminate. So I might have to exercise my rights under the Fifth Amendment to that one.
That is a good answer. My mother asked a little more serious question, and this goes to how you spend your time to let people know more about you. How do you like to get your hands dirty? We like to ski, but that's kind of a pedestrian sport. What
Wow, spoken like an Arizonan there, the Valley of the Sun. No, our family loves to ski together. That is one of our favorite activities. My daughters are ferocious double black diamond skiers. One of them is...
That's not pedestrian at all.
One of them is right now doing some backcountry skiing out near Telluride as we speak. So that's something we love to do as a family.
And where does your family vacation?
Near Winter Park, Colorado. Mm-hmm. It's a resort owned by the city of Denver. And it's where I learned to ski as a kid. My parents would put me on a bus or the train. It was their idea of getting rid of me for the day on the weekend, and I'd come back exhausted, which was good too. They like to run me ragged that way.
What's the largest trout you've ever caught?
Oh, now we're talking. All right, I love to fish, and that is where I find a lot of solace. You can't focus on the worries of the world when you're only worried about a trout. Everything else goes away, just disappears. And you're in the most beautiful... Trout live in beautiful places.
They do.
They're very picky, and they pick well. So during the summertime, fishing, hiking, I like to row, I like to run. Those are my activities. And I like to read. I like to read novels. Good fiction. And if you want to learn how to write, you got to learn how to read.
That's right. That's great. Tell me about your civic involvement outside of the courtroom. You mentioned school board a while ago.
Yeah, boy, that I found taxing, and loved every minute of it. But I've spent a lot of my free time teaching or working on the Rules Committee. Been in the rules process for the last 6-7 years now. Chief Justice kindly appointed me to the Standing Committee and then to the Appellate Rules Committee more recently, and trying to make the rules more sensible so that we can get litigation done more sensibly, cheaper, faster, for all people. It's a wonderful example of government working. People from a variety of walks of life, judges, lawyers, academics coming together and operating more or less by consensus. Imagine that.
Mm-hmm. Well, I've found that as well, and I think that typifies the West and small towns. I grew up in a town called Snowflake. I'm a fifth-generation Arizonan. You're fourth-generation Coloradan, I understand. That is how it works. People get along. They have to. And on a school board, there's no passing the buck there. You've got to make decisions. Local government is like that. Jury duty. Have you ever been called up?
You know, I have. It was when I was at the Department of Justice, and I thought for sure
Have you served on a jury? I'll give him.
No, I just thought it was very odd questions for this, but it's great. It's
Well,
great.
you know,
it's nice.
you know,
I thought it was pertinent. I wanted to know.
I'm
Can
a
a judge
big-
be called for jury?
I'm sorry I laughed. It caught me
No.
by something. Go ahead.
Thank you. I actually think it's a very excellent question, because I think anyone who served on a jury appreciates the important civic function that's involved. It's a way citizens are actually interact with their government, right, in a very real way.
Were you disqualified, or did
I thought for sure I'd get kicked off. And I guess, neither side thought I was the worst one. So I made it through, and I went to the bathroom when we sent back, and I came out and I'd been elected foreman, which I refused to serve as. But I just didn't think that was appropriate, and I didn't want to have undue influence. But, the Seventh Amendment and the right to a trial by jury, the only disagreement our founders had over it was whether it was a bulwark of liberty or the very palladium of liberty. And as a trial lawyer, I had great faith in jurors, in the collective wisdom of 12 citizens to adjudicate a case fairly on the facts. And my time serving in a jury, I wondered, is it going to prove out my beliefs, or am I going to come out more of a cynic? I came out more optimistic and a truer believer in the jury system than ever. I really believe in the wisdom of juries.
Thanks.
That was a great question.
Thanks, Al.
Yeah.
Appreciate it. It's the end of the day, I see. You mentioned earlier that your colleagues on the 10th Circuit. Can you tell me about them? What do you admire about some of them? What have you learned from some of them?
Oh, there's so many I admire. I admire them all. They all bring something to the table. Men, women, from every kind of background.
Tell me how it works. Are you bunched up, or these were Republican-appointed judges, these are Democrat-appointed judges? Do you notice that? Do you forget that? How is it?
The nicest gift I've gotten in the last few weeks, there have been so many prayers, so many well-wishers, so many kindnesses. But the best gift I've gotten was this enormous basket from my 4 most recent colleagues. I think it was 4, whatever. It just happens to be my Obama-appointed colleagues sent me a gift basket because they knew I wasn't eating very well as I was marching around the Senate halls, and they said I was looking a little gaunt. That's how we work in the 10th Circuit. And I'm sorry for outing them, but you touch my heart. Thank you. And that's how my colleagues are, all of them. I've served with judges appointed by President Johnson, President Nixon, President Carter, President Reagan, President Bush I, Clinton, President Bush II, and Obama. And we get along. And I think you're going to hear in a couple of days from 2 former chief judges of the 10th Circuit who've retired now. You're going to hear about how we operate in the 10th Circuit. It's often reputed to be the most collegial circuit in the country. Collegial not in some ordinary pedestrian sense of we're just nice to one another. Collegial in a real meaningful sense. We listen to one another, and we value and we respect different points of view, not just tolerate them.
Just for the record, the 10th Circuit is 7 active judges appointed by Democrats, 5 by Republicans. Yet of the 2,700 cases for which you have sat, you've filed dissents on just 36. Is that right? 1.3%. And of the 25 dissents that Judge Gorsuch has authored, more than half, 52%, were from majority opinions written by Republican appointees. So for those, and it's been said or implied that you act in a partisan way somehow, or that former work in the political arena before you became a judge if that has somehow bled over into your judgeship. It certainly is not reflected in what the record shows. I think even more telling, as Congressional Research Service shows, 97% of the majority opinions that you authored were for a unanimous court. As you mentioned, you worked together. In over 98% of all cases in which you sat, there's this what you agreed with the majority result, 99% of the time. That does not sound like an ideologue. That does not sound like someone far out of the mainstream. And so when I hear that on television or whatnot, people say that this is a judge way out of the mainstream, it simply doesn't ring true from your record, with your record. Let me submit for the record a statement from a former law clerk. I think she was mentioned earlier. She said that soon after you took the bench on the 10th Circuit, he said, quoting, "He took all of his clerks and office staff, myself included, to visit several federal prisons. He wanted to see for himself, and he wanted all of us to understand the importance of applying justice in every case. For the lives of others depended on us doing the best job that we possibly could." Can you tell me about that experience?
Senator, federal criminal law imposes very long sentences. And to be a judge complicit in adjudicating criminal cases, I thought I couldn't close my eyes to what the reality is. And I wanted to see it for myself firsthand my first year on the bench. So I did.
Can you tell me about the 10th Circuit Capital Habeas Project?
Oh, Senator, I think it started one day after an argument when a few of us were concerned that the quality of representation of death row inmates in our circuit was not what we'd like it to be. And I do not want to take more credit than I'm due here. Real people deserve credit. My colleagues, Judge Timkovich, Judge Lucero, and a whole lot of our staff, Betsy Shoemaker, David Tye, many, many others, who put together with the wonderful judges in Oklahoma, some training sessions, recruited additional lawyers, provided training for those who are already in the system, sought and obtained more funds for federal public defenders to assist. And a lot of people deserve more credit than I do.
Thank you. Let's talk about Western issues for a bit. We talked about the importance of geographic diversity on the court. And people are saying, well, what does that mean? Is there really a difference? Is there really a Western perspective that somebody can bring? Let me go through a few of the issues that you've encountered, and we'll flesh that out. Let me introduce, for the record, a letter from one of Judge Gorsuch's former clerks. Well, also, let's do it from a federal judge in Montana. But let me talk about for a second some of the policies that come out. In one case, you rejected the idea that a dormant commerce clause prevents Colorado from requiring that 20% of electricity would come from renewable sources. Now, whether or not you agree with that policy, and there's a lot of disagreement around here about that, but we don't live in Colorado. You do. So its wisdom isn't really our business. Would you agree that the principles of federalism allow states to experiment with policies like environmental protection in this sense?
Senator, that was the holding of my court in that case. Colorado had passed by voter referendum a law that, as I recall, sitting here, indicated that 20% of energy in Colorado had to be from renewable sources by a date certain. That law was challenged by fossil fuel producers out of state, alleging that it violated what's called the Dormant Commerce Clause under the federal Constitution and case law interpreting it. And I did write for a unanimous panel that there was no constitutional violation and the state was permitted to proceed with its experiment.
Is that indicative of the concept of laboratories of democracy that states have been described as?
Consistent with that principle.
All right. Well, thank you. One complicated issue that we have in the West that you really don't get as much elsewhere is the split estate property rights. It's possible that I might own a parcel of land, but somebody else might own the mineral rights, and still somebody else might own the water rights. Have you encountered that in your jurisprudence?
It is very different than out here. And yes, I have. Split estates, as you know, are a common feature in the West, and in part, at least, a byproduct of homesteading acts by this Congress, where initially, as I recall, Congress gave homesteaders rights down to the center of the earth, as is common out here. Mm-hmm. Then they found out, my gosh, there's some valuable stuff under there, and they started splitting the estates so that homesteaders could do what they wanted to do on the surface estate, but that the Congress and the people could control some of the valuable mineral rights underneath. Very complicated stuff. Yes, I've encountered those cases too.
Is that a perspective that you think would be useful on the Supreme Court?
I think that's for this body to decide.
All right. Well, thank you. Also, another aspect of living in the American West is that we share a lot of land with the Indian tribes. And the prevalence of tribes out west can complicate things in the legal sense. Say, deciding between municipalities or local or state government. What have you ruled on or have you dealt with in terms of relationship between state and local government and the tribes?
Senator, I've had a number of tribal cases. And tribes are, as you know, sovereign nations. And our constitutional order affords this body considerable power in dealing with those sovereign nations, by treaty and otherwise. And out west, there are all sorts of variations on that arrangement. There are classic reservations, as many people in the East conceive of them. There are also ancient pueblos that predate this country by many hundreds of years. Then there are allotments to individuals and groups. Depends where you are. That sounds like Oklahoma. Pueblo sounds like New Mexico. Mm-hmm. And then when I think of reservations, I think of Utah and some places in Colorado and Wyoming. And there are variations all throughout the American West. Mm-hmm. You know, our history with Native Americans is not the prettiest history. And as a judge, you try very hard to administer the law fairly without respect to persons and equally. And I'd point you to my cases involving the Ute Indian tribe, where they've had a long time trying to control their tribal lands. Or Fletcher, involving the Osage Nation in Oklahoma, and the right to an accounting of the property due them under agreements with the United States. Try to treat all persons who come before me fairly.
That's also a perspective that a Western member can bring to the Supreme Court. That's my supposition. I know you won't say that, but I think that that's useful. While the chairman is here, let me ask for unanimous consent to enter into the record a letter from Alaska senators on behalf of Indian tribes.
Yes.
Also, one from a law school clerk, and also one from a judge in Montana.
Those documents, without objection, will be entered.
Thank you. Let's turn for a minute to the separation of powers. You've written eloquently about Chevron deference and your concerns. I share those concerns. Chevron didn't come out of nowhere. There were serious concerns in the 1980s with rogue judges making policy from the bench. Now, the idea of agency deference was designed to restrain judicial overreach. I think that the pendulum has swung far too far in the other direction, and that the judiciary is insufficiently vigilant of executive overreach. What are your thoughts on that?
Senator, those are policy considerations. As a judge, my job is to look at the law. I would say I don't conceive of Chevron deference as conservative or liberal issue. I do recall when Chevron was announced, many people thought it was a very conservative decision because it does advantage whoever has their hands on the reins of the administrative state at the particular time. And in 1984, that was one party. Today, maybe another party, and the next day it may be another party. So a good judge doesn't care who it advantages. A good judge looks at the law.
So setting the boundaries for where deference ought to be is the job of the legislature and not the judicial branch.
Well, in the first instance, the Administrative Procedures Act is the statute that you look at.
Right. Thank you. With regard to the Second Amendment, you've been asked about stare decisis and the role of precedent, and it's usually by those who talk about Roe versus Wade or decisions like that, but they rarely bring up that might also apply to Heller or other decisions like that. How do you see it with regard to precedent?
All precedent of the United States Supreme Court deserves the respect of precedent, which is quite a lot. It's the anchor of the law. It's the starting place for a judge. And the chairman kindly held up my overlong book, right? And that's the law of precedent, a very mainstream consensus view by a bunch of judges from across the country got together, and we wrote it down. And it's all in there. And Justice Breyer was kind enough to write a foreword to it. And it articulates how a good judge goes about assessing the law of precedent in any case.
All right. Thank you. Let me just close with religious liberty, religious freedom. I would not ask you your religion or how you practice your faith. But if you can just talk in general about what the role of faith is, or people of faith coming into the judiciary or on the courts. What role should it play? What role should it not play, in your view?
Senator, one of the wonders of our constitutional order is the First Amendment and the right of free exercise. Not many countries in the world are as pluralistic when it comes to religion as this country. It's quite an experiment, really. Right? Most nation states, one culture, one people, one religion. We're founded on a very different idea, that all voices are heard, that people of all faiths and no faiths are welcome, that we're tolerant. It was quite an experiment to launch 200 years ago. It's still an experiment today that we're working on and learning to live with one another and mediate it. So the role of religion in our society is profound and always has been. And it's a pluralistic commitment we have in this country that's, very special in the world.
Mm-hmm. Well, thank you. Well, Mr. Chairman, I'll do something very unsenatorial. I've got a couple minutes left, but I'll yield back so people can go vote.
Yeah, okay.
Or is he's not back?
I'll stay here. I think Senator Blumenthal will be here for, I'll stay just a few minutes, so we will just stand in recess. I hope everybody will kind of stay close by.
Thank you, Mr. Chairman.
Senator Blumenthal, I'll call on him. And Senator Blumenthal, while I'm gone, if you have anything that you want to put in the record, just ask your permission to do it, and you can do it.
I thank you very much, Mr. Chairman. I have 2 sets of documents, and with your permission, I will enter them into the record.
Yes, okay.
Thank you.
I'm going to go vote now.
Just us.
Good evening, Your Honor, and thank you for your patience and your perseverance with us. You'll recall the conversation or visit we had in my office not that long ago, and you will, I'm sure, recall that I quoted the first line in your concurrence in the case of Gutierrez v. Brizuela. You remember that first line?
Senator, I'm sorry, I don't remember the first line. But
the line was, "There's an elephant in the room with us today."
Yes, yes.
It's been cited before.
Yes,
today.
yes.
And do you recall what I said or who I said was the elephant in the room?
I'm sorry, Senator, I don't. I apologize sincerely.
I'll refresh your recollection. The initials are DJT.
Okay.
Donald Trump.
Yep.
He was the elephant in the room with us then. I think he's the elephant in the room with us now. And the reason is, as I said then, because of his attack on the judiciary. And make no mistake, I am not in any way attributing to you that attack, but you are familiar with the fact that he referred to the Article III judge who ruled against him in the travel ban case as a, quote, so-called judge in one of his tweets. You recall?
I do.
Tweet? And do you recall his second tweet when he referred to the court and said that they were to be, quote, given blame if an act of terrorism occurred because of striking down the travel ban? You recall that tweet?
Yeah, yes, Senator.
And during the campaign, a completely different federal judge, born in this country, he said could not rule fairly on his case because the judge was, quote, a Mexican. You recall that?
I do.
What do you think the president meant when he used the words so-called judge?
Senator, I don't know what was in his mind. You'd have to ask him.
How would you feel if he called you a so-called judge?
Senator, I care deeply about the independence of the judiciary. I can't talk about specific cases or controversies that might come before me. And I can't get involved in politics. But I can say a couple of things about that, as you know. The first is, judges have to be tough. We get called lots of names all over the place. We have to accept criticism with some humility. It makes us stronger and better. I take it from my teenage daughters. I take it from litigants. This process, there's been plenty of criticism, and that's fine. Thomas Jefferson didn't much like Marbury versus Madison, and he didn't mind saying so. Presidents have tried to pack the court. That's part of our constitutional history. We have a First Amendment. People can speak their mind. But, Senator, I'm sorry, I don't mean to interrupt, but I did want to add one other point, if I may.
Please do.
But, Senator, when you attack the integrity or honesty or independence of a judge, their motives, as we sometimes hear, Senator, I know the men and women of the federal judiciary, a lot of them. I know how hard their job is, how much they often give up to do it, the difficult circumstances in which they do it. It's a lonely job, too. I'm not asking for any crocodile tears or anything like that. I'm just saying I know these people, and I know how decent they are. And when anyone criticizes the honesty or integrity, the motives of a federal judge, well, I find that disheartening. I find that demoralizing, because I know the truth.
Anyone, including the President of the United States?
Anyone is anyone.
Because no person is above the law, including the President of the United States.
That's right, Senator.
And isn't that reference by the President to a so-called judge, isn't his attack on the same judges who struck down that order as playing politics? Isn't that an attack on the judiciary?
And I can't get involved in politics. I've said what I think I ethically may in this area.
Well, maybe you can share with the President what that wise old judge told you. Maybe you can quote it to us again.
I think you're going to hear from him yourself on Thursday. And I'm sure he won't mind to hesitate or in any way have any question of fear about saying it to you himself. But I'm happy to share it with you, too.
The ultimate test of
the rule of law is whether the government can lose in its own courts and accept the judgments of those courts.
And in your view, was the President of the United States showing proper respect when he attacked the courts in that way? Was he accepting the rule of law?
Senator, I've gone as far as I can go ethically with the canons that restrict me about speaking on cases. I can't talk about specific cases, and I can't get involved in politics. Respectfully, I believe I've gone as far as I'm able to go.
Well, I just want to make clear that I'm looking for the same kind of expression of outrage that I felt as an officer of the court, and I am still an officer of the court because of that attack. Because as you well know, and I cited it yesterday, Alexander Hamilton said the courts are the least dangerous branch because they have neither the power of purse nor sword. What they have is respect. When the President of the United States attacks the court, attacking you, because when he attacks your brethren, he attacks you, the bedrock of our democracy, you as a member of the 10th Circuit Court of Appeal, as a so-called judge. He undermines the bedrock of our democracy, which is respect for the courts. Courts don't have armies, they don't have police forces. All they have is the respect and credibility. And you made reference earlier to judges having to take the barbs and insults. My guess is that if a litigant before your court, and the President of the United States was a litigant in that case, used that language, you might well entertain a motion for contempt of court.
I appreciate the opportunity to talk about my record, because I can talk about that, Senator. My record is when there's a judge who's accused of perhaps using language that might bear on a man's ethnicity, arguably, in the course of sentencing. The panel of my court on which I sat replaced it. My record is that when an undocumented immigrant, is not properly represented, and there's a history of the lawyer failing his clients in that area, sent him, referred him for dismissal from our bar.
Because you believe that respect for the courts is important.
Senator, the independence and integrity of the judiciary is in my bones.
Well, I'm going to return to this topic, maybe not in this round, but later, because, as you well know also, although judges may be attacked, they really have no way to defend themselves. And we know that as officers of the court, as advocates, and that's why I feel so deeply that not only we, but the Department of Justice should have been more vigorous in coming to the defense of those judges, even though the Department of Justice was the loser in that case, because more is at stake here than the president's immigrant or policies or the travel ban. It is the respect and integrity for the courts. There's another reason that Donald Trump is the elephant in the room, and that is because he established a litmus test, or actually a set of litmus tests, one of them being that his nominee, and I don't know whether you saw the debate, the third presidential debate, where he promised, and I'm quoting, about overturning Roe v. Wade, quote, "That'll happen automatically, in my opinion, because I am putting pro-life justices on the court." Are you familiar with that statement?
I am, Senator.
Are you familiar with other occasions when he promised that he would appoint someone who would overturn Roe v. Wade? For example, November 13, 2017, in an interview with Leslie Stahl on 60 Minutes, quote, "I'm pro-life, the judges will be pro-life." On June 28, 2015, an interview on CNN with Jake Tapper, quote, "I'm pro-life." He was then asked, would that be a litmus test? Quote, it is, end quote. There are others, but what I'm asking you is, you're aware of that litmus test.
Senator, I can't say I'm aware of each of those statements, but I'm definitely aware that there was discussion of litmus tests by lots of people during the election process. Yes.
Well, these discussions are by the President of the United States,
Yes.
who has nominated you for this position.
Very aware of it, Senator.
And he interviewed you,
He did.
and you've testified here that there was no mention of Roe v. Wade.
Senator, what I've testified to is that there was no request for me to commit on any case or controversy or anything that might come before me.
Was there any mention of Roe v. Wade?
There was, briefly.
And what did he say and what did you say?
Yeah. Senator, the President recounted to me, among other things, how the campaign went in Colorado. He knew I was from Colorado, and he was disappointed he had lost Colorado. And he said something like if he'd had a little more time, he thinks he might have won it. And then he said that one of the topics that came up during the course of the campaign was abortion, and that it was very divisive and split people evenly, he found. And then he moved on to other topics.
Did he mention Roe v. Wade by name?
I don't think so, not to my recollection, just that abortion was very divisive, and then he moved on to other topics that of interest to him.
Like what?
Senator, the next topic I remember, and this is just my recollection, is he expressed concern that our country's nuclear armaments are old.
Has anyone in interviews with you, and you mentioned one conversation with Steve Bannon, I understand you also met with other advisors, has anyone else ever mentioned Roe v. Wade?
No, Senator. That's it.
Never a mention of that case or of abortion in any of your conversations with any of the President's advisors?
Not to my recollection, no.
And what about with officials of the Heritage Foundation who may have discussed the Supreme Court with you?
To my knowledge, Senator, from the time of the election to the time of my nomination, I've not spoken to anyone that I know of from Heritage. Maybe I've shaken someone's hand, but I've not had any substantive conversation that I'm aware of that anyone's alerted me to that they're from the Heritage Foundation.
Well, let me go to a case that I think bears on perhaps the President's and his advisors' perception of your views on Roe v. Wade and on this issue of abortion. I don't know whether you recall the case of Planned Parenthood Association of Utah versus Herbert.
I do.
In that case, as you know, the governor of Utah directed all of his state agencies to end funding for the local Planned Parenthood affiliate after a deceptive and false set of videos was released. And Planned Parenthood of Utah went to federal court. They sought a temporary injunction. They won. They lost at the district court, which denied their request. And then on your court, a 3-judge panel reversed the district court and granted the injunction, stopping the state government from terminating the funding. That restored the funding for Planned Parenthood.
Temporarily, as a preliminary matter. That's my recollection, yes.
As a preliminary matter, the panel of the 10th Circuit restored the funding.
Issued a preliminary injunction or a TR, probably preliminary injunction. Yeah.
Correct. Preliminary injunction is correct. Were you on that panel?
No, Senator, I was not.
Okay. And any of the parties subsequently have the right to ask for a rehearing, do they not?
They do.
Is there a time limit?
For the parties, there is a time limit prescribed by rule. It's also possible for the court, what we call sua sponte, or on its own, to seek rehearing, and there's no time limit prescribed by rule for that.
So the time limit for the parties is 2 weeks, correct?
That sounds right, Senator. I wouldn't swear to it, but I trust you.
Well, I would never presume to know the rules.
I always check the rules on that sort of thing because I always think I know, and it's 10 days or 14 days, or so I always look.
I'm sure you do. Well, 2 weeks passed, and none of the parties requested a rehearing, correct?
That's right. That's right.
But one of the judges did.
That's right.
That judge was you.
Senator, that's internal deliberative process that wouldn't normally be revealed, but I have no problem acknowledging that.
That you asked for the rehearing?
I did.
The parties actually were fine with the result. They settled a case. They were off about their business, and you asked for the rehearing, correct?
No, Senator, that's not correct.
Well, correct me.
A preliminary injunction, the Court of Appeals, the panel had indicated should issue, subject to the district court has to enter it, I believe. I don't think our court entered it directly. As I recall, the parties either reached some sort of agreement with respect to the preliminary relief, or the court entered it. I don't recall which, but the case proceeded. It may still be proceeding for all I know.
But one way or the other, none of the parties asked for any further proceedings, only you did.
That's right.
And did the court decide to grant an en banc hearing?
Very narrowly voted against it, Senator. It was a close vote.
And you dissented?
I did.
Now, you know Rule 35 says, and I'm quoting, an en banc hearing is not favored and ordinarily will not be ordered.
Oh, of course. It's an extraordinary thing. We probably hear between 0 and 3 en bancs a year over the course of my time. Don't hold me to that, but it's somewhere in that range usually.
Out of your 10 plus years, 11 years on the court, how many times have you asked, you yourself, sua sponte, asked for a rehearing in a case where you were not even on the panel?
Oh, I've done it, Senator. I can't tell you how many times sitting here. I just can't. But I can tell you I've done it. And I can tell you, Senator, that about 1 out of every 5 en bancs, about 20% of en bancs in our court are sua sponte. It's not unusual.
By this time, the funding was going to Planned Parenthood, correct?
I don't know. I don't know.
It is a matter of, I believe, public record that it was, in fact, restored. And the parties never asked for that en banc hearing. Let me ask you, what was the exceptional importance of this case that prompted you to seek a rehearing en banc?
I appreciate the opportunity to answer that question, Senator. En banc rehearings happen sua sponte with regularity in our court. As I say, maybe 20% estimate of the cases that we've heard during my time have been sua sponte. It's acknowledged in the committee reports to the rules. Wright and Miller, the Bible on civil procedure that every young lawyer lives with, acknowledges the regularity and the propriety of sua sponte en banc. So just to put that aside, I just don't see any.
I'm asking you about your reasons.
And now,
and by the way, I know you don't have a number, but maybe you can supply it, because I'm willing to bet that that number is a tiny, minute fraction of the 2,700 cases.
Of course.
And even of all of the cases where you have dissented.
Of course. I'd be very reluctant.
Give me 1 second. I think something happened. I don't know why it got stuck. Just give me 1 second.
An implication of impropriety, anything like that, Senator, I'd appreciate the chance.
Absolutely.
Okay.
I'm not even asking for extra time, Mr. Chairman.
Senator,
please proceed.
Yeah, Senator, it's all about standards of review for me. In that case, the parties agreed on the law. There was no dispute of law. In that case, everyone agreed that if the governor had discontinued funding because he opposed lawful abortions, that would be unconstitutional and wrong. and would have to be stricken by the court. That was uncontested. It was also uncontested that if the governor discontinued funding because of his reaction to videos that you're well aware of involving alleged unlawful action, alleged, then his conduct was lawful and constitutional. The law was agreed by everyone. The only question was, what was the governor's intention? That's it. And the district court made a factual finding that the governor's intentions were what he said they were, that he acted in response to the videos. That was his testimony. That was the district court's finding. And in a very unusual, I thought, step, our court overturned the factual finding of a district court and did so on the basis of a putative admission from the governor's brief, as if the lawyers for the governor would concede away their case. I read the brief. It didn't concede away the case. And it seems to me very important, Senator, that we abide our standards of review. And we don't pick and choose the areas of law to start abandoning our standards of review. And the standard of review for clear error, for factual findings, is what I wrote about. And I don't care if the case is about abortion or widgets or anything else. When a jury or a district judge makes a factual finding, that deserves our respect under a clear error standard review. As you point out, Judge Bachrach, while he didn't think it rose to the level of en banc review, he thought the panel was clearly wrong. And he happens to be, as you know, just happens to be a democratically appointed judge, because we're judges first. And Senator, there were 4 judges who wanted en banc in that case. That's a large number in our circuit. There's nothing unusual or untoward about that case at all. It's what we do as judges.
Do you recall the date of your dissent?
I don't, Senator.
Would it surprise you to know that it was, the case was pending in July of 2016. Your dissent was sometime in that time period at the height of the presidential campaign.
I would have said it was in the summer, Senator, yes. I would say I've also, Senator, revived partially a lawsuit brought by Planned Parenthood in another case. I take the parties as I find them, and I take the facts and laws that come to me. And I don't choose when they come to me or how they come to me.
I understand.
And any other implication would be erroneous.
Let me ask you, we talked about precedent, and precedent is important as law, correct?
Yes.
And people rely on it. That's one of the key criteria that you've established for sustaining precedent, and I'm not even sure that the term has been used here, but stare decisis, which is an important principle of following well-established and accepted law. Let me ask you, did you agree, or do you agree with the result in Brown v. Board of Education?
Senator, Brown versus Board of Education corrected an erroneous decision, a badly erroneous decision, and vindicated a dissent by the first Justice Harlan in Plessy versus Ferguson, where he correctly identified that separate to advantage one race can never be equal.
And do you agree with the result?
In Plessy, no, absolutely
No, you agree
not.
with the result in Brown v. Board?
Brown versus Board of Education, Senator, was a correct application of the law of precedent. And
So you agree with it?
Senator, it is a correct application of the law of precedent.
By the way, when Chief Justice Roberts testified before this committee, and he was asked by Senator Kennedy, quote, do you agree with the court's conclusion, meaning in Brown, that the segregation of children in public schools solely on the base of race is unconstitutional? Judge Robert answered unequivocally, quote, I do.
Senator,
would you agree with Judge Roberts?
Senator, there's no daylight here.
Okay.
Justice Harlan got the original meaning of the Equal Protection Clause right the first time. And the court recognized that belatedly. It's one of the great stains on the Supreme Court's history that it took it so long to get to that decision.
Do you agree with the court's this outcome, the result, in Griswold v. Connecticut and Eisenstadt v. Baird? And you know that they struck down a ban on contraception. I believe it's been discussed earlier.
Yeah. So,
do you agree with the result in those cases?
So Griswold, Senator, as you know, held that the 14th Amendment due process liberty clause provided a right to married couples to the use of contraceptive devices in the privacy of their own home. And then Eisenstadt extended that to single persons.
Right.
Senator, those are precedents in the United States Supreme Court. They've been settled for 50 years, nearly, in the case of Griswold. There are reliance interests that are obvious. They've been reaffirmed many times. I do not see a realistic possibility that a state would pass a law attempting to undo that, or that a court of the United States would take such a challenge seriously.
I have a very simple question for you. Do you agree with the result?
Senator, I'll give you the same answer.
Again, I just want to tell you what Justice Alito said in response to that question. He said, very simply, talking about Eisenstadt, quote, I do agree with the result in Eisenstadt.
It was an application of equal protection principles.
Well, I know what it was. I'm asking you for a direct, clear, unequivocal answer.
And Senator, I'm trying to give it to you. And as I recall, Justice Alito said the same thing, which is that there's an equal protection argument. Once you have Griswold in place, then it follows, as a matter of equal protection, that the same, what was true for married couples is true for single persons. And that was an application of settled equal protection principles.
I want to tell you what Chief Justice Roberts said when he was asked the same question about Griswold. He said, quote, I agree with the Griswold court's conclusion that marital privacy extends to contraception and availability of that. My time is about to expire. I just want to say I hope that when we resume questioning, that perhaps you can give me somewhat more direct and unequivocal answers in the same way that Roberts, Alito, Justices Roberts and Alito and Kennedy did to the same questions. Thank you, Mr. Chairman.
Senator from Idaho. Thank you, Mr. Chairman. And Judge Gorsuch, first of all, I want to thank you for preparing yourself for this opportunity and for this service to the United States. You have acquitted yourself very well today. In fact, I'm very impressed with your knowledge of the cases and your ability to understand and articulate your positions on the issues. I have a couple of tough questions for you first. Is it true that you have been endorsed by John Elway?
You know, Senator, a couple of things have made my day recently, and hearing that was definitely one of them. You know, in Colorado, I mean, where I come from, that's big stuff.
Well, it is. And, you know, some of us Westerners who don't have a pro team in our state kind of agree with that as well.
Senator, I'll tell you, what meant as much to me, though, was an article I saw not too long ago someone put in front of me from the Albuquerque Journal. And it quoted two lawyers who appear in front of me all the time. One's a civil rights attorney. The other represents indigent criminal defendants, routinely in my court. They win some, they lose some. And they both went out of their way to say, he's a fair judge. And you know what? The compliment of the people who work with me day in and day out, who win some and who lose some, that means the world to me.
That's very impressive. And at the end of my opportunity to ask questions here, I'm going to submit a statement for the record that has been submitted by another one of your associates and friends who endorses the way you have conducted yourself on the bench. It's good to have good friends who will stand up for you. Another tough question. I appreciated the discussion that Senator Flake and you had about fishing. This is going to test your true abilities as a fisherman. Would you tell me where your favorite fishing stream is? And don't say No Tell'em Creek.
Do I have to answer this question, Mr. Chairman?
No, you don't have to answer it. At least not publicly.
I'd be happy to share with you privately my views on this subject.
We'll talk.
My experience is, though, that once the word gets out,
Then it's not there.
then it's not my favorite spot anymore.
Okay, you've just proven yourself as a fisherman. I also wanted to just tell you, I appreciated the conversation you had with one of my other colleagues here about your law clerks. I, too, am a law clerk. I don't know that you knew probably the judge I worked for, Judge James M. Carter, on the Ninth Circuit. He passed away in 1979. He was appointed by Harry Truman to be a district judge in Southern California, and then by Lyndon Johnson to be a circuit court judge on the Ninth Circuit. And I had the experience as his law clerk that you described your experience to be, and those who serve as your law clerks. And I just wanted to tell you, you connected with me on that. I truly appreciated that bit of just learning more of your human side in that context. I want to go, this is also a point in this hearing that pretty much everything has been said, but not everybody's gotten an opportunity to ask you to say it. And I apologize if some of the things are repetitive, but some issues keep coming up. And I want to get back into some of the core issues and just give you an opportunity to restate the case. And a couple of those are pretty obvious. In fact, our chairman started out with this first issue, and that is, what is the role of a judge? I have before me here the statutory oath that we give to judges. I'll just read part of it. It is to administer justice without respect to persons and do equal right to the poor and to the rich. And it also says to faithfully and impartially discharge and perform all the duties incumbent upon the judge under the Constitution and the laws of the United States. That's some pretty high-minded language. What is your opinion of the role of a justice on the Supreme Court?
Senator, it's the same thing. Doesn't change. It's a more public role. There may be more civic education involved, or at least an opportunity. Somebody might listen to you a little bit more. And Justice O'Connor, again, comes to mind here. But the job doesn't change, and the law is the law. It's what we do day in and day out. And the discussions about the judiciary, I think, often miss the fact that judges agree overwhelmingly on the disposition of cases. A tiny percentage of the cases go to the Supreme Court of the United States, 70, 80 cases a year, a fraction of a percent. And even then, the justices of the United States Supreme Court are unanimous in their decisions 40% of the time. Now think about that. You have not just 3 judges who have to agree, as on the Court of Appeal, generally speaking, but 9. 9 justices who are appointed by 5 different presidents right now. And people say the world's changed. But in some ways, it hasn't, because that 40% number has been remarkably steady since the Second World War. That's a pretty incredible thing when you think about it. That's a testament to our rule of law. It's human, it's imperfect, but it's sure better than anything else anybody's ever devised.
Well, that commitment to interpreting and applying the law honestly, fairly, and impartially is critical. It's what we need in Supreme Court justices. And again, I appreciate your answer on that question. Now, again, I apologize that this is a repetitive question. In fact, you were just asked it in another way just now, but it's one that keeps coming up and which I expect is going to be a discussion point for the rest of this process, and that is the litmus test issue. You've already said it, but I'm going to ask you to say it again. Did anyone in the nomination process, the president included, require of you a commitment of any kind of a litmus test as to how you would rule on any issue and in any case whatsoever?
No, Senator, and if they had, I would have walked out of the room. Period.
So to put it another way, if you had to, you would, if the requirements of the law were that you had to rule against the President of the United States in a case, you would do so.
Senator, if that's where the law and the facts lead me, do it without hesitation. I've done it. I've done it many times without respect to who is in charge. I rule for the government sometimes. I rule for the accused, for the prisoner, for the immigrant, for the student, for the employee, whomever it is, based on the law and the facts of the particular case at hand. And I believe, respectfully, my record demonstrates that.
I think it does too. And there has been some questioning here today about, this is my characterization of it, but I think it's pretty clear, a desire to get you to get involved in the politics of the court, as though there is an appropriate role for a judge to be a politician or to be involved in politics. I remember in our meeting in my office, you were quite emphatic about the fact that you would not let your politics get into your job as a judge or a justice. Could you comment on that?
Senator, it really comes from my experience as a lawyer. And General Cottrell put it better than I could. But the fact of the matter is, I represented plaintiffs, I represented defendants, I represented the big guy, I represented the little guy, however you want to call it. And in each and every case, all I wanted was a judge who didn't decide the case based on his personal beliefs, her personal religion, his politics, what she had for breakfast. I just wanted someone to come in and look at the law and look at the facts, study it as hard as they could, and make as neutral and dispassionate a judgment as they could. That's what I wanted. A human judge, somebody who's a person. It helped if they were kind, but I'd take a curmudgeon. There were some curmudgeons. Fair curmudgeon any day of the week I'd take.
Yep.
I wanted fair judge. And I resolved to myself that I would remember, so long as I was on the bench, I would remember what it was like to be in the well, what it was like to have to make the arguments. Because I'll tell you what, asking the questions, a lot easier than having the answers. I sleep a lot better the night before argument as a judge than I did the night before argument as a lawyer. And so I resolved I wanted to be the kind of judge that I wanted when I was a lawyer.
Well, thank you. Now, let's move on to the question of precedent. Could you generally, again, I realize this is repetitive, again, tell us your view of precedent, particularly as a Supreme Court justice, if you are to be confirmed, what you believe the proper role of precedent is?
Senator, precedent's the starting point for any good judge. Precedent is our history, our shared history, our patrimony, the wisdom of the ages, if you want to think of it that way. And it would be foolish of any judge to come in and think that he or she knows better than everybody who's come before him. That'd be an act of hubris. So the starting point and the great anchor of the law, as Francis Bacon called it, is precedent. As Hamilton said, judges, because we're life tenured, need to be bound down by strict rules and precedents. And I take that obligation seriously.
So that people can know what to expect out of the law.
Reliance is a huge part of it.
Now, it does turn out, particularly at the level of the Supreme Court, that there are times when precedent is revisited. Could you tell us when it is appropriate? How does a person, particularly a Supreme Court justice, how should a Supreme Court justice approach that question?
The same way a circuit judge approaches the question with circuit precedent. We do the same thing. Nothing changes. It's the same set of principles.
So what process do you go through to make the decision that you should revisit precedent?
Start with a presumption in favor of history, and that people who came before you were just as smart or maybe even smarter than you are. When you put on the robe, you lose the ego. You look at the reliance interests that have formed around the precedent. You look at how long it's been around. You look at, see whether it's been reaffirmed. You look at the quality of the initial decision. You look at the doctrine and whether it's been built up around it or whether it's eroded away. You look at workability. Those are some of the factors a good judge looks at. when deciding any challenge to a precedent.
And I assume it's not a decision reached lightly.
Senator, no decision should be reached lightly as a judge.
Well said. I want to move on now to one that you have been asked a little bit about today, but not a lot, and that is the 10th Amendment to the Constitution, which says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, and I think some people stop there, or to the people. This is the issue of federalism. I've got a few specific questions, but could you just discuss with me in general your feelings about that amendment and what it means in our American jurisprudence?
Well, Senator, it's part of the Bill of Rights, like all the rest of the Bill of Rights. And it was thought important to add as part of the first 10 amendments to the Constitution as a package. And the thought was to emphasize and make very clear that the federal government is a government of enumerated powers, not a plenary government with unenumerated, unlimited power, and that there was reserved to the people and to the states abundant rights.
I agree with that. A lot of my constituents, and frankly a lot of people that I talk to around the country, believe that that has pretty much been eroded in the sense that the place where there is authority reserved to the states is a very small place today. Because of certain Supreme Court rulings, because of certain doctrines relating to the Commerce Clause and others, it is felt that the place in which the federal government is free to assert its authority, even to the point of superseding state authority, is so large now that the 10th Amendment has lost much of its meaning. Could you comment on that?
Well, Senator, 10th Amendment cases do come before the court, and related Commerce Clause challenges that are kind of an analog here. So I have to be careful.
Understood.
But I'd point you to the New York case, Justice O'Connor again, pointing out that there are limits to how far the Congress and the federal government may go to commandeer state governments. And then, of course, there's the Chief Justice's opinion in the ACA case with regard to Medicaid expansion and the limits of the Commerce Clause power there. So there are a couple of decisions that are out there that you're aware of that discuss this issue.
I think that the discussions that have been had today about the Chevron case get into this arena. Earlier, when you were asked questions about it, you indicated that in your, and again, I realize you may not be able to go very far in this answer, but I'd like to give you an opportunity to explain it as much as you can. I believe in the decision that you wrote, you said the elephant in the room was the question of deference to executive agency actions. That's a rough paraphrasing of what you were discussing. And I believe you said that there were due process, equal protection, and separation of powers issues related to that. Could you expand on that a little bit?
Well, Senator, I'd be happy to, of course. In that case, again, involved an undocumented immigrant. And the question was whether an agency could overturn judicial precedent retroactively so that this man who had relied on our precedent essentially had the legal rug pulled out from underneath him. And it seemed to me that that raised a variety of questions. First, it meant now that he had to wait not 10 years outside of the country, but perhaps 13 or 14, because they wanted to retroactively overturn judicial precedent. And I ask, in terms of fair notice, advance notice, due process, how is a person, the least amongst us, anyone, supposed to organize their affairs, rely on the law, precedent, if it can be overturned by an agency willy-nilly? What are the equal protection implications if the person who declares the law is now a political branch rather than the judicial branch, where selective picking and choosing of winners and losers can be had in the application of the law. I'm worried about that. I worry about the separation of powers. How is it that an agency can overturn a judicial precedent effectively without the concurrence of Congress? Congress, of course, has the power to write statutes. Last time I checked, that's the legislative power, though, and to overturn judicial precedents on statutory interpretation. That's this body's role. So those were some of the things I worried about, and I worried about just the plain old statutory text, too, of the APA, in which Congress is assigned the task, of course, of fact-finding to the agencies, and told us, again, to provide a highly deferential standard of review to the agencies, the chemists, the biologists, the scientists, but said when it comes to interpreting the law, that the courts are supposed to do that. So those were some of the questions that I found difficult in that case.
Well, I appreciate the perspective that you have. Again, still talking about federalism and the 10th Amendment, you're familiar with the Dormant Commerce Clause concept.
Yes.
Could you describe what that means to you?
Well, the Commerce Clause appears in Article 1. Article 1 affords this body and the House of Representatives the power to legislate interstate commerce, among many other things. That is the Commerce Clause, the non-sleeping, the non-dormant Commerce Clause.
Right.
But we have this sleeping thing over here. And it's the product of judicial interpretation that suggests that sometimes, even when Congress hasn't exercised its powers under the Commerce Clause, states infringe Congress's authority by stepping into the regulation of interstate commerce themselves in a way that, though Congress has not itself prescribed, would still offend congressional authority. That's the doctrine.
Correct.
Okay.
So that's how I understand it as well. And I realize that you may not be able to go much further in discussing your feelings about that doctrine, but if you can, I welcome you to.
Well, Senator, I've tried to make clear today that my feelings, respectfully, on any of these topics are things I try to leave behind. And I try to take the facts and the law and the precedent before me very seriously. I come here with no agenda but one. No promises but one. To be as good and faithful a judge as I know how to be. That's it. And I can't promise or agree or pledge anything more than that to this Congress. I just can't. Not as a good judge. Not as someone who has to look litigants in the eye and tell them I'm a fair and impartial judge of their case. Not as someone who respects the separation of powers. So that's where I come from on that.
Thank you very much, and I respect that. And frankly, America is very fortunate to have someone who strongly holds to that perspective nominated to this critically important position. I just want to clear up one other thing, and then there's a few issues I just wanted you to also discuss a little bit further with me. Back to the Hobby Lobby case, I just wanted to give you an opportunity to clear one thing up, at least for me. Maybe everybody else understood this very clearly. That case went to the Supreme Court and was resolved in a 5-4 decision. But if I understand the rulings correctly, of the 4 judges who dissented, only 2 of them felt that the issue relating to a for-profit corporation was dispositive. Did I get that right? Or objected to that part of the ruling. Is that correct?
That's right. The other 2 dissenters did not feel the need to reach that issue.
I just wanted to be sure that was
That's right.
Was made clear in the record. In the time I have left, which is about 8 minutes, I'd just like to ask you about several of the things that I believe you have written about. First is the 7th Amendment right to trial. I understand that you have written about that. Is that correct?
I have, Senator.
What are your thoughts about that?
Senator, I believe in juries. I liked trying cases to juries. I liked being on a jury. I think it's a part of our civic engagement that's really valuable. People feel connected to their government. Hamilton and Madison, I think it was, I can't remember which, in the Federalist Papers debated, is it a bulwark of liberty or is it the very palladium of liberty? That's what they thought of the Seventh Amendment. And I think it's just so difficult for litigants to get to a jury now. And we spend so much time in preliminary discovery, what we call discovery, motions practice. Lawyers become poets of the nastygram. They can write interrogatories in iambic pentameter. But there just aren't that many jury trials anymore. And I'm not sure that's a good thing.
Does this relate to your writings also about, or your concerns about access to justice?
Yes, Senator. Yes.
Could you expand on that a little bit?
Well, when it becomes so expensive and takes so long to get to a jury, to get to a trial, some people don't bring good claims. A lot of people are left not bringing good claims to court. That's a problem on the one side of the V. And I saw that as a lawyer. And on the other side of the V, defendants, sometimes you feel like you have to settle, not because the case has merit, but because the cost and the delay to the client are so significant in getting to a decision. Just can't afford to do it. Got to get on. And as I indicated earlier, the American College of Trial Lawyers, and both represent both plaintiffs and defendants, have indicated both these problems are real in our system and need to be addressed.
Thank you. The last issue I'll ask you about is your thoughts, which you've already referenced somewhat, on overcriminalization in the law. Could you basically just reiterate that for us?
Yes, Senator. As I indicated earlier, I think the number is something like 5,000 federal criminal statutes on the books today, and hundreds of thousands in the Federal Register. That 8-point font, I need to bring out my reading glasses when I pull open the Federal Register. And, I have a hard time reading it. And I have a hard time imagining the American people can read it, to be honest with you. And Madison warned about a world in which written law is lacking. And he also warned about a world in which we'd have too much written law, paper blizzard. So much so that the prosecutor can choose his charges with impunity, and the people don't have notice, really, what's expected of them. So I think both of those things on both ends of the spectrum are a concern. And Aristotle was right there, too. We're looking for a golden mean.
Well, and I think earlier today you also referenced maybe you meant to in these comments, the regulatory explosion of criminal penalties. Is that a part of this as well?
I would say it's been part of, I don't know about an explosion, but it's just a fact of life that's been with us for a while and growing.
Yeah, I won't ask you to comment on this, but I think it's an explosion, and not just in the criminal side, in the civil side as well, just the regulatory growth that we have seen in our government recently. This is not an issue for you, at least to discuss with me today, but I think we have a lot of difficulty simply because of the complexity that we are creating in our legal system. And many of those difficulties will need to be resolved at the policy level. I understand that. Judge Gorsuch, again, I just want to thank you for being willing to step up and do this service. It was notable to me, I think you said earlier, that Justice White only spent about 90 minutes in his hearing. Is that correct?
That's what I'm told.
Remarkable. Thank you again.
Enviable. No, this has been a great pleasure, a great honor to be here with you, Senator, and with all of your colleagues.
Well, we understand what you and your family. Thank you again.
Enviable. No, this has been a great pleasure, a great honor to be here with you, Senator, and with all of your colleagues.
Well, we understand what you and your family and friends are going through. We know the commitment that you have made simply to agree to be nominated and move forward through this process. And I want to thank you for doing that as well. I truly do appreciate it. Thank you very much. And before I yield my time, I would like to ask unanimous consent first to enter a letter into the record from the President of the Colorado Farm Bureau endorsing Judge Gorsuch. Secondly, a letter from Todd Seelman, managing partner at the Denver office of, I'll probably mispronounce this, Louis Brisbois, Bisgard, and Smith in support of Judge Gorsuch's nomination. Another letter from the Lincoln's Inn Society of Harvard Law School, which is a number of people who know you from this group and who have commented on your humility, thoughtfulness, and intellect, which we have seen today. And then finally, an article from a Colorado District Court judge, John Kane, in which he rebuts basically the notion that there's any kind of ideological bias in your record. And I think says very positive things about Judge Gorsuch. I'd ask unanimous consent to put these documents into the record.
Without objection, the documents will be entered into the record. The
Thank you very much.
Senator from Hawaii.
Thank you, Mr. Chairman. The end is nearing for today, Judge Gorsuch. We've sat here for close to 10 hours now, and you have not told us your understanding of cases already decided by the Supreme Court, except to say that they are law and precedent. You have not told us your view of cases currently before the court, and you will not tell us your view on issues that might someday be presented to the court. In fact, you have provided us less in the way of answers about how you would approach cases than previous nominees to the Supreme Court. So how should we divine what you would bring to the Supreme Court in terms of your judicial philosophy? By looking at your judicial record, by looking at your writings? I see a pattern that is very much on a par with the Roberts Court's steady march toward protecting corporate interests over individual rights. That is not protecting the rights of the minority, as you told me in our meeting, which is the purpose of Article 3. So I hope that in answering my questions, you can provide some reassurances that you will be a judge or justice for all Americans. You had an extended discussion today with Senator Franken about your dissent in the Trans Am trucking case. I want to talk to you about another case, Longhorn Services Company v. Perez, in which you overruled an agency decision about worker safety. You were in the majority in a 2-to-1 decision, could have gone the other way if you had gone that way, that overturned a sanction against the company based on a strained distinction between a floor hole and a floor opening. The dissenting judge, a President George W. Bush appointee, described this distinction as nonsense and said the distinction between a floor hole and a floor opening did not matter in this case because the company was in violation of an OSHA standard either way. Why did you believe it was appropriate to rely on a strained distinction between floor hole and floor opening at odds with the law's intent and purpose to protect worker safety?
Senator, I appreciate the opportunity to address that. As I think you've indicated, I was not the author of that opinion. I didn't write it. One of my colleagues wrote that opinion. Another one of my colleagues dissented. You're quite right about that. I don't have a dog in the hunt when it comes to holes and openings and floors, but apparently OSHA does. OSHA distinguishes between floor holes and floor openings when it comes to spaces.
Excuse me, Judge. That case held that you overruled the agency decision,
Yes.
which did not make a distinction.
With respect, Senator, OSHA regulations do make a distinction between, as I recall, it's been a while, but
Not in this case, sir.
Well, Senator, there are different regulations for floor openings and floor holes in, I think this is an oil and gas rig or maybe a fracking rig. And what you have to do in terms of remediation, cover or a handrail, there are different consequences, whether it's a hole or an opening, as I recall. And the party there, nobody was injured, but they got a fine for not doing, maybe covering it up, I don't recall, whatever the agency wanted them to do. And the question is whether they've been provided notice they were being charged with, whether it was a hole versus an opening. And Senator, all I was trying to do there, I agreed with my colleague who wrote the majority opinion, that OSHA charged what it charged, it had to prove, and that it can't change the charge in the middle of the proceedings, as I recall.
Well, the dissent indicated that this distinction was nonsense, and therefore
Well, that might be true.
Yes.
I mean, I don't know. As I say, I don't have a dog in that hunt. I'm just trying to apply the OSHA regulation.
If I can go on. So that law, though, was for the purpose of worker safety. And I think you responded to one of the questions from my colleagues that you do look to the purpose of the law, and that is what judges should effect. So the purpose of that law was worker safety. So I'm really not understanding why you went with the majority in making that kind of distinction. Let me move on. Earlier, you had an extensive discussion, as I mentioned, with Senator Franken about Trans Am trucking and whether you understood the impossible choice your decision would have given to the driver in that case, Alphonse Madden. And if your decision had been the majority, which it wasn't, it would have made a driver like Mr. Madden choose between endangering his own life and health or keeping his job. I'm hoping that you will share more about your approach to cases like transfer trucking. Your dissent dismissed the argument that the law should be interpreted in light of its purpose of protecting public health and safety, saying that those goals were too ephemeral and generic. Did the purposes of this law to protect an employee from being fired for acting in response to safety concerns play any role in your decision?
Senator, I appreciate the opportunity to talk about this again. The statute there protected individuals who refused to operate a motor vehicle. And at least as I saw it, and this is just one judge and how I saw one case in 10 years, and I saw that the individual drove away. He operated the motor vehicle. And so I didn't see how he could claim protection of a statute that hinges on a refusal to operate. I'm relieved to know that he was fine and was able to meet up with his employer 15 minutes or so later, as I remember the record. But my heart goes out to him, and I said that in the opinion that he was put in a rotten position. And I go home at night with cases where sometimes the law requires results that I personally would not prefer.
I think that you could possibly have interpreted the definition or the requirement that he actually refused to drive the vehicle. He refused to drive the vehicle with the attached trailer. That's what but you could have held, I would think, that he refused to drive the vehicle in an unsafe way. So, I mean, the way I look at this decision, and you were not in the majority, is that if judges are going to work this hard to strain the text of the law to undermine the purpose, which was for the safety, and that a driver who made a decision based on that would not be fired, I think that makes it pretty tough for any laws that Congress passes or will pass to really be effective in protecting American workers. I'd like to turn to Citizens United. In this case, the court adopted a narrow view that only quid pro quo corruption counts regarding campaign contributions, and that appearance of corruption, basically, which had also been a concern, is out the window. This has unquestionably changed the landscape of our elections, unleashing a flood of corporate money in campaigns. If corporations are able to spend unfettered money on American elections, what is there to stop a foreign company from funneling money into our elections through its American subsidiary? For example, what limits would prevent a Russian oligarch from financing a $1 billion independent expenditure operation through an American middleman?
Well, Senator, I appreciate the opportunity to answer that. If I might, though, I just point to my record on employment cases. There are plenty of cases where I've ruled for the employee and not the employer. We can pick one and talk about one, but there are many, many where I've ruled for the employee, even overturning the district court when the district court ruled for the employer. Lots of them. And I'd be happy to talk about any of them.
Well, I'm not.
But if we want
I'm not asking you about the others.
understand.
So can you respond to my question about Citizens United and unfettered foreign money that can come into our campaigns?
Senator, I'd say that there's lots of room for congressional regulation here. And that, in fact, the Supreme Court has made clear that foreign money in particular is an area where Congress has substantial authority available to it.
I'd just like a clarification then. You're saying that Citizens United leaves open for Congress to prohibit foreign money in our elections? Isn't that already happening?
Senator, I would say there's ample room in the area of campaign finance for further legislation. All sorts of room that the court's made clear remains. It struck down one law. That does not mean that every law will be stricken. It does not mean that Congress has no role. It means that Congress passed one law that, based on one record, the Supreme Court found to violate the First Amendment.
So since there's so much concern about foreign money and foreign governments attempting to interfere or really interfere with our elections, and if Congress were to pass a law that prohibited foreign contributions through middlemen or any other way, you would sustain that law?
Senator, I'm not making any promises to anyone about how I'd rule. I understand people would like me to make promises, but I just, that's not what a good judge does. It's not fair to the parties. I don't prejudge cases. It would be a violation of the separation of powers, in my view. It would be the end of the independent judiciary. Senator, what I would promise you to do is to look carefully at the record with deference to the fact finder, to look at the briefs, to go through the whole judicial process and carefully consider all the arguments made by both sides, as a good judge does.
Thank you. You've articulated that many times. The sheer volume of speech brought by corporate money drowns out the voices of everyday Americans on important issues. I'm concerned with influence peddling in politics, such as from billion-dollar donors like the Mercers or Philip Anschutz. Judge Gorsuch, given that you've volunteered on numerous Republican political campaigns dating back to the 1970s, were you ever concerned with the flood of unfettered money in our elections and campaigns?
Senator, the first campaign I worked on, I was about 9 years old. It was my mom's. She was running for the state house. And I think it was, again, her idea of daycare.
So Judge
I'd walk with her.
I'm sorry, I have only 18 minutes left. And had you ever been concerned, because certainly you worked on political campaigns when you were beyond 9 years old.
I did.
Was there ever a time when you were concerned about unfettered money in our political campaigns?
Senator, I have lots of concerns as a person and as a citizen, but I'm now a judge. And my personal views have nothing to do with how I rule on cases. It's a discipline that a judge learns and exercises and hopefully improves upon over time. And I'm steadfast about that, Senator. It means the world to me as a lawyer and as a judge who cares about an independent judiciary. It comes from a place deep in my bones.
I'd like to move on.
Of course.
I listened to your conversation with Senator Coons about the Hobby Lobby case. And it's a decision that you joined in the 10th Circuit and was supported by the Roberts Court. And in that case, you decided that a corporation with 23,000 employees has rights to the exercise of religion protected by the Religious Freedom Restoration Act, and that it could use those rights to deny the thousands of women that it employed access to certain kinds of health coverage. And there was a notable dissent in the Supreme Court's Hobby Lobby decision by Justice Ginsburg, joined by the two other women on the Supreme Court. And Justice Ginsburg wrote, quote, the exception sought by Hobby Lobby and Conestoga would deny legions of women who do not hold their employees' beliefs access to contraceptive coverage. How much did you consider the significant need of the 23,000 Hobby Lobby employees, of which a significant number of them were women working paycheck to paycheck, for access to health care that they would now be denied?
Senator, I appreciate that question. The answer is I considered it very closely, very carefully. So did the Supreme Court of the United States, which affirmed our court. And as you know, the Religious Freedom Restoration Act goes above and beyond the First Amendment in protecting religious liberties. It's a judgment made by this Congress that it's free to amend at any time if it wishes. It can eliminate corporations from coverage. It can eliminate the strict scrutiny that's required. And it can eliminate the act at any time. But, Senator, I gave every aspect of that case very close consideration. That was an en banc decision by our court.
You did write a concurring opinion on that.
I did.
And I think your concurrent opinion could even be deemed an expansion of the plaintiff's rights in that case. So, in your view, the corporation did make claims about contraception based on religious beliefs which are directly contravened by scientific research. And by accepting as facts these religious beliefs and probing no further and agreeing that the corporation could deny coverage, the Hobby Lobby decision leaves us in a tough spot. So are there any limits? And if so, what are those limits on what a corporation may claim as a belief in justifying its denial of health care for its employees?
Senator, the sincerity of the belief, I believe, was undisputed by the government, at least in our court. So I just don't think that was at issue. Are there limits to how far the statute goes? Yes, there are. The government may force someone to forego and accept a substantial burden on their sincerely held religious belief if it can prove a compelling interest, which the Supreme Court accepted in this case, and can also show that it's the most narrowly tailored way to achieve that compelling interest. It's strict scrutiny. It's the highest standard known to law. And the problem in that case, again, as the Supreme Court and my court saw it, was that the government had managed to find a way to achieve its compelling interest in providing coverage to women in many other cases without requiring any compromise.
So I realize that the compelling state interest was conceded to the government, but my question really relates to the first part of the test, which is the sincerely held belief.
Yes.
And while that may not have been an issue in this case, even though if you were to look at their sincerely held beliefs, then there was evidence that some of their beliefs were scientifically not valid. So my question is really, how would you go behind the sincerely held belief to determine whether there's really a basis for this belief?
You're asking me whether I would, as a judge, decide that someone's sincerely held religious belief is wrong?
Well, based on scientific evidence or some other factual evidence?
So that I, as a judge, I just want to make sure I understand the question, that I would say that the belief is scientifically invalid and therefore not protected by the statute? Is that the question?
Well, therefore could not be a sincerely held belief.
Sometimes a court will hold that a belief is not sincerely held. That's true. That does happen. I've had a case involving just that scenario, and it involved a group of drug distributors who claimed they worshipped marijuana.
Yes. I was here when you responded to that.
Okay.
And, you know, I hate to be rude, but I'm down to less than 12 minutes. So if you don't mind, sir, I'd like to go on to another area. In 1942, an ordinary American took an extraordinary stand. His name was Fred Korematsu, who boldly opposed the forced internment of Japanese Americans during World War II. After being convicted for failing to report for relocation, Mr. Korematsu took his case all the way to the Supreme Court, and the High Court ruled against him. It took 39 years before a California judge overturned Mr. Korematsu's conviction in another proceeding, but the Supreme Court never overruled Korematsu. So Korematsu has joined the short list of the most regrettable decisions in the court's history. And even though most American citizens of Japanese ancestry were loyal, the court in Korematsu found that the government's curfew and internment program was constitutionally acceptable because some unknown faction or fraction of that group posed a special statistical risk of disloyalty and danger. Today, if the court were to assess special restrictions on U.S. citizens of Iranian, Yemeni, Somalian, Syrian, Libyan, and Sudanese ancestry, do you believe Korematsu would be applicable precedent for the court to consider?
No. And let me compliment Neil Katyal. When he was acting Solicitor General of the United States, he confessed error by the government in that case. That was an admirable move.
Thank you for that yes and no answer. I appreciate that. Going on to Hamdan. During your time as a senior official in the Bush Justice Department, you appeared to play a significant role in developing and promoting the arguments in Hamdan v. Rumsfeld, including the argument that the president himself had the power to set up military tribunals to try Guantanamo detainees without key human rights and other protections in the Geneva Convention and the Uniform Code of Military Justice. Judge Derek Watson, a Hawaii Federal District Court judge, recently issued a stay of significant portions of President Trump's second executive order banning nationals from 6 predominantly Muslim countries. And without commenting on the current case, do you believe that there are executive orders that are outside the scope of appropriate judicial review to determine if a president has overstepped his constitutional authority?
Senator, to me, one of the beautiful things about our system of justice is that any person can file a lawsuit about anything against anyone at any time. Any person has access to our courts of justice on any subject, and a judge, a neutral and fair judge, will hear it. I think that's a remarkable thing. It doesn't happen everywhere in the world.
Is your answer that there is no executive order that would not be judicially reviewable?
Well, Senator, a lawsuit can be filed on it. What a court will do with it is a matter of the judicial process, and we'd have to go through assessing what the claim is, what the defenses are, take evidence, hear the arguments, make a decision.
I understand. The court could say it's a political issue and not take it. Senior White House advisor Stephen Miller, who has been described as the architect of the Muslim ban, recently criticized the actions of federal courts in staying the initial travel ban on national TV. And Mr. Miller said that Donald Trump's national security decisions, and I quote, will not be questioned. I take it that you don't agree with Mr. Miller that there are areas like national security where the president's decisions, quote, will not be questioned even by a court, even by the Supreme Court. I take it you do.
Senator, I give you the same answer, that the beauty of our system, and I don't want to eat up your time, but the beauty of our system is that anybody can bring a complaint to court and have an opportunity to be heard under the laws of our land. It's a remarkable thing when you think about it.
The person who nominated you, Judge Gorsuch, does not have much respect for judges or courts. As a candidate for president, and now even as president, he has belittled and berated judges who do not rubber stamp his views. He attacked Judge Curiel, his family's heritage, and his fairness while he was presiding over the Trump University fraud case. He sought to bully Judge Robart, who decided the first case challenging the constitutionality of his anti-Muslim travel ban. He sought to intimidate the Ninth Circuit, and more recently has belittled Judge Watson.
We're going to do a good job. More importantly, we're going to do a great job. And then we're going to win it the old-fashioned way. We're just going to win it. And I want to thank everybody. This is a lot more than 200 people. This is a hell of a big room. Yeah. That's far back. Can you see over there? See, I would have gotten rid of these columns, actually. But that's being a construction man. But that was a long time ago. They didn't do that. Well, it's an honor to address you tonight and thank each and every one of you for your role in helping to build, sustain, and grow a truly strong Republican Party again. In this effort, we will be working hand in hand with our House leadership team, and I've really gotten to know them, and they are winners, and they are terrific people. Terrific people. Speaker Paul Ryan, Leader Kevin McCarthy, Majority Whip Steve Scalise, and Conference Chairwoman Kathy McMorris Rogers. What a group. Great group. Also with us tonight, a man who I have a lot of respect for, gave me a very early endorsement, former Vice President Dick Cheney, along with his daughter, Congressman Liz Cheney. Where is he? Thank you, Dick. Thank you. Thank you, Liz. I also want to thank the chairman of the Republican Congressional, look, what a group, committee. Where is Steve? Where is he? They lost him backstage. Steve Stivers, where is he? Steve, what the hell happened? I think he left. Everyone's looking. It's the second time he's been introduced. Steve, are you there? Oh. Come here, Steve. What a job you did. Come here, Steve. He's embarrassed. Come here. Come on. Get up here, Steve. Come here.
Thank you, Mr. President.
Just say.
Thank you. Thanks, everybody.
Well, that's what I like.
Thank you.
Come here, man.
Great job.
See, that's a real worker. Oh, boy. No talk, all action, right? We like people like that. Congratulations to Steve. And March dinner chairman, Steve Womack, and the NRCC finance chair, Ann Wagner. Thank you. Thank you. Thank you, Ann. Thank you. The work of the NRCC never ends. In fact, we have 4 special elections currently underway in Georgia. We won. Montana, we won. Kansas, we won. And South Carolina. We love South Carolina. That's some group. Where's South Carolina? Oh, we love South Carolina. Remember, I was supposed to lose that one big, and we won by 21 points, and that's when I found out these polls are rigged. They were rigged. Thank you, South Carolina. I learned a lot in South Carolina. Our nominees from Montana and Kansas are here with us this evening. Greg Giafonte and Ron Estes. Thank you. Thank you very much. Thank you. On November 8th, the American people voted for historic change, and they also voted for serious action by delivering the House, the Senate, and the White House. The American people gave us clear instructions. It's time to get busy, get to work, and to get the job done. That legislative effort begins with Thursday's crucial vote. And it really is a crucial vote for the Republican Party and for the people of our country to finally repeal and replace the disaster known as Obamacare. That's what it is, a disaster. Premiums have soared double digits and even triple digits. Insurance companies are fleeing. 1/3 of counties only have one Obamacare insurer left. I was in Tennessee 4 nights ago. They've lost half the state. The insurance companies are gone, and they're going to lose the next one pretty soon, from what they say. And last night in Kentucky, we had a tremendous crowd, 25,000 people more, and a similar crowd in Tennessee, by the way, packed, with thousands of people outside. They couldn't get them into these massive arenas. There's something going on that's really incredible in this country. It's really incredible. But Kentucky also is having a tremendous problem, as you know, and as you've read, with Obamacare and many other states. The House bill ends the Obamacare nightmare and gives health care decisions back to the states and back to the American people. These are the conservative solutions we campaigned on, and these are the conservative solutions the American people asked us as a group to deliver. We are keeping our promises. I go to these arenas, and they have signs all over the place. He's kept his promise. He's kept his promise, because I've done a lot of work. The border is in the best shape it's been in decades, down 61% since inauguration. General Kelly, you know, they used to put political people. I refuse to say political hacks, because I would not say that, because there is no such thing as a political hack. But they would put nice political people at the border. I put General Kelly, recommended by General Mad Dog Mattis. I said to him, General Mattis, I said, General, I need somebody really smart and really tough for the border. Sir, I have the man. General Kelly. As soon as I saw him, it was like an interview lasted for about 30 seconds. I said, he's the right guy. And he's been great. And General Mattis has been great. You see what's going on. Big difference. It's been 60 days since my inauguration, and that was a promise that I've really kept. As you saw today in the Senate, I nominated a Supreme Court justice who will uphold and defend the Constitution of the United States. I've taken historic action to eliminate unnecessary job-killing regulations, and we've just started on that one. But we've gotten rid of a lot of them. That includes eliminating regulations, crushing our coal industry. We're going to put our great coal miners back to work. Clean coal, clean coal. I've cleared the way for the Dakota Access and Keystone XL pipelines and added a requirement that American pipelines be constructed with American steel. That was the last minute. I said, where are we getting the steel? I won't tell you where, but you can guess. I said, from now on, we have to go. You got to build them here. You want to put pipelines under our land, you're going to make the pipe in this country. And one other thing happened, I have to tell you, it's sort of interesting. So I get a call from the ex-president of Goldman Sachs, who now works for us, Gary Cohn. I said to him, Gary, let me ask you, I heard there was a lawsuit. I hear the pipeline company is suing us. I said, how much? $14 billion. I said, wait a minute. I'm approving a pipeline, and they're suing us for $14 billion, and I've already approved it, right? I said, I just heard it. Go back to them and tell them if they don't drop the suit immediately, we are going to terminate the deal. You have great, being president gives you great power, right? Amazing. So I just saw him this morning and said, by the way, how did you do? He said, sir, they dropped the suit. Good, that's good. Isn't that easier? Look, if I'm up, do you think Hillary does that? I don't think so. I don't think so. Isn't that easier, though, than settling for like $4 billion in 7 years from now? But the lawyers aren't happy at all. They don't like it. We've got a lot of lawyers in this crowd. They're not happy about that deal. Because of the new business climate that we're creating, jobs are already starting to pour back in. Companies like Sprint, Intel, ExxonMobil, where a great man, Rex Tillerson, is doing an incredible job. Incredible. Ran that company for many years and ran it well. Walmart, Ford, Fiat Chrysler, General Motors have all announced that they're keeping or adding tens of thousands of jobs right here in America. It's a big difference. You used to hear they're all leaving. Now they're all coming back. They're coming back, too, believe me. And if they don't, we're taxing the hell out of their product, so you know they're coming back. Why didn't somebody start doing that 25 years ago? One company said, sir, we're building a big plant. There's nothing we can do to stop it. It's already under construction. I said, here's the story. When you make your cars or whatever, and you fire all our American employees, and then you think in your new plant, beautiful new plant, congratulations, you're going to sell that product across our border tax-free, you're wrong. 35% tax. It's amazing how quickly they say, I think we've decided to stay in the United States. I only wonder, why didn't somebody do this like 25 years ago? You would have had nobody leaving. So far, I think I'm batting about 100%. To save taxpayer dollars, I've already begun negotiating better contracts for the federal government, saving over $700 million on just one set of airplanes, of which there are many sets. As I promised during the campaign, I have proposed a budget that eliminates the defense sequester and fully rebuilds the United States military. We need it more than ever. We need it more than ever. We've got a lot of haters out there. They hate. We got some people running some countries that are bad people. We will take care of it. We will ensure that the America warrior, and if you think about it, the great American warriors, because that's what they are given the tools, the funding, the resources, the training, and equipment they so richly deserve. They are warriors. And they have old equipment. They're not going to have old equipment much longer. And we will take care of our great veterans. What's happening there is going to be incredible. Finally, we're going to take care of our veterans. Our defense expansion will fully pay. And this will be something that is so important. It will be fully paid by making government leaner, more accountable, and just perfect for our people. But I will tell you, if it's not fully paid, because we're doing a big number with the planes and the ships. Our Navy is at World War I levels. Can you believe that? World War I levels. So if we don't fully pay, we're going to do a little work, but we're going to get our military rebuilt bigger and better and stronger than ever because we have no choice, folks. There's some bad players out there, and it's going to go quickly. I have also followed through on my promise to secure, protect, and defend the borders of the United States. And yes, we will build a great border wall at our southern border. Will be built. These security actions will save billions of dollars, millions of jobs, and thousands of lives. We're also taking decisive action to improve our vetting procedures. The courts are not helping us, I have to be honest with you. It's ridiculous. Somebody said I should not criticize judges. Okay, I'll criticize judges. To keep criminals and terrorists the hell out of our country. We are keeping these promises and many, many more. After we repeal and replace Obamacare, our Republican majority will pass massive, historic tax reform, the biggest tax cut since Ronald Reagan, and potentially even bigger. Going to be very big. And by the way, we had no choice, had to go with the health care first. You know how it works. This is one room that really does know how it works. But we had to go with the health care first. And we're doing well. I think we're going to have some great surprises. I hope that it's going to all work out. Then we immediately start on the tax cuts, and they're going to be really fantastic. And I am looking forward to that one. That one's going to be fun. That one's going to be fun. That's called the wheelhouse. We're going to do a great job for companies. We're going to bring back, could be $3 to $5 trillion from overseas, money that can't be brought back as part of our taxes. And it will lower the business tax rate from one of the highest in the world to one of the most competitive anywhere in the world, way, way down. We will do everything we can to lower business burdens and to make it easier for our businesses to thrive and compete, but in exchange, they must hire, invest, and grow in America, or we're not giving them anything, okay? They got to do that. That's the one thing. We're working with the automobile industry, who have been played around with. And I'm saying, we'll do things for you, but you got to build new plants all over the place. You got to build new plants in our country. And they're doing it. They're starting. It's going to be amazing. I have called this model, the model that you've been watching, the model that's created so much value, the model of bringing back jobs and bringing back industry. I've called it the American model. And this is the system that our founders wanted. Our greatest American leaders, including George Washington, Hamilton, Jackson, Lincoln, they all agreed that for America to be a strong nation, it must also be a great manufacturing nation. Have to make money. The Republican platform of 1896, more than a century ago, stated that protection and reciprocity are twin measures of American policy and go hand in hand. I mean, we have situations where other countries who have zero respect for our country, by the way, did you notice they're starting to respect us a lot? A lot. A lot. They'll charge us 100% tax in some cases, 100%, and we charge them nothing. They'll make it impossible through regulations for our product to be sold in their country, and yet they'll sell their product routinely in our country. Not going to happen anymore. The word reciprocity. They do it, we do it. Who can complain about that? Big difference. You're talking about big, big dollars, too, by the way. The platform went on to say, we renew and emphasize our allegiance to the policy of protection as the bulwark of American industrial independence and the foundation of American development and prosperity. Now, these are some of our greatest leaders, some of whom were great business people. They understood we have to do it. And just so you understand, I'm a free trader, but free trade has been very unfair trade. So I now say I'm a fair trader. And I want to trade all over the world. I don't want to have it just here. But we're going to be beneficiaries from now on. We're not going to be the people that are taken advantage of any longer. That's been happening for decades and decades. It's not going to happen any longer. And they know it. One country came in to see me recently. Big country, good country, great person. One of his first questions, sir, how much will you be charging us? It's like, he knew. He knew. He knew. They've been ripping us for years, and he finally saw somebody that understands. So one of those things. You don't mind having a rich nation again and having lower taxes, do you? Does anybody here mind? If anybody minds, please stand up. I know Dick Cheney will not stand on this one. Please stand up. As long as the GOP stands for Made in the USA. Remember in the old days, cars, also Made in the USA, right? We don't have that too much anymore. We're going to have it again soon. I'm telling all the car companies, put a big label, Made in the USA. It's going to stand for quality. Our party will have a very, very bright future. It is fitting that we are in the National Building Museum. Since its founding, the Republican Party has been a party of builders. Many of the great builders are in this audience tonight. Some of them I have to compete with, and I don't like very many of them, but, you know. Some of them I do. Some of them I truly dislike a lot. But now I like everybody. I like all the great builders. See, and now it's different. Now we're all on the same side. So I like, see the guy over there? I couldn't stand that guy for years. He did a good job, but I couldn't stand him. Now I like you. Our first Republican president, Abraham Lincoln, ran his first campaign for public office in 1832 when he was only 23 years old. He began by imagining the benefits a railroad could bring to his port of Illinois without ever having seen a steam-powered train. He had no idea, and yet he knew what it could be. 30 years later, as president, Lincoln signed the law that built the first transcontinental railroad, uniting our country from ocean to ocean. Great president. Most people don't even know he was a Republican, right? Does anyone know? A lot of people don't know that. We have to build that up a little bit more. Let's take an ad. Let's use one of those packs. Those packs. You never know what the hell's going to come out of those packs. You think they're friendly. Although the best ad I ever had was one done against me by Hillary. It was so good. I said, I hope that she keeps running that ad. Another great Republican president, Dwight Eisenhower, had a vision of a national infrastructure plan. As an officer in the Army after World War I, he joined a military convoy that trekked across the nation to the Pacific coast. It traveled along the Lincoln Highway, called then the Lincoln Highway. Its journey began by the south lawn of the White House at a monument known today as Zero Milestone. Anybody know where that is? The journey made a great impression on then young Eisenhower. More than 3 decades later, as president, he signed the bill that created our great interstate highway system, once again uniting us as a nation. Now is the time for a new Republican administration working with our Republican Congress to pass the next great infrastructure bill. Our party must dream as big and as bold as Lincoln and Eisenhower. Together, Republicans will lead America into our unbelievable future. We have so much potential. We have so much potential. I see it now even more than I saw it in this great campaign, which turned out to be a movement like the world has never seen before, actually. You know, it's funny, I've said that so often, they don't even correct me, the fake media. They never correct me, because it's true. Oh, believe me, if it's off by 0.01%, it's like I end up getting Pinocchios, right? They don't even correct me. One of the great movements of all time. Imagine, and it's not my movement, it's a movement of the people. It's been something that's really been very special. I'm like a messenger. I'm nothing more than a messenger. I'm a messenger. I did a good job as a messenger, but I'm a messenger. It's been a lot of fun, too. Imagine the breakthroughs that will breathe fresh life into forgotten places. Picture the new roads that will carve pathways all across our land, and we need them. And think of the new inventions that will lift up the sights of our nation. Finally, as we imagine this new prosperity at home, let us also work to achieve real and enduring peace abroad. People don't realize, I have to say, what a mess we inherited, what we have. I'm telling you, you look at North Korea, you look at the Middle East, you look all over, you look at that horrible, horrible, horrible Iran deal. I still have not been able to figure out why anybody would have signed that deal. I ask generals, I have them in my office, I say, General, please tell me, why did they sign that deal? Unbelievable. But we're going to straighten things out, folks. The best Republican presidents have not only been war fighters, but also peacemakers. We will never hesitate to do what we must to keep us safe today, but we will always seek a more peaceful tomorrow. We will, and we will succeed. If we stand for these things, safety, prosperity, and peace, then there is no limit to what we can achieve. A future where millions are lifted from welfare to work, and they're going to love it. They're going to love it. They're going to love waking up in the morning, going to work. Communities thriving with jobs and surging with commerce. Inner cities filled with new hope and new opportunities. Schools where our children can learn free from violence and free from fear. And new frontiers in science, technology, and space that inspire the next generation of American youth. All of this and so much more is possible. Our country is great. A new national pride is stirring our souls. A new optimism is sweeping our land. A new era of American greatness is just beginning. Somewhere in America tonight, a child is born in poverty, looking up into the sky and filling their heart with dreams, big, beautiful, bold dreams. And if we make the right choices together, then no one will ever have to tell that child that their dreams will have to wait for another day, another year, or another decade. Because the waiting now is over. The time for action is now. This is the moment when great deeds are done, and we will do those great deeds by putting our faith in the people and by putting our trust in God. We will rise to this occasion like no one has ever risen before. Thank you so much. Thank you. Great people, great country. Thank you so much. We will prove worthy of this moment. Anything is possible if we stand together, united and strong, not just as Republicans, but as great and unified Americans. Join me in believing in this better and brighter future. Join me in building this reality, and join me in rededicating ourselves to the common good of this nation that we all love so much. Together we will defend our freedoms, we will defend our people, and we will defend our great and beautiful American flag. Thank you. God bless you, and God bless the United States of America. Thank you very much.
All right, folks, thank you very much for joining us and choosing us as your stream of choice. The Gorsuch hearing already ended. It will continue tomorrow. Hope that you guys join us. And thank you very much for your continued support. Hold on, give me 1 second here. Yeah, thank you very much for your continued support, and we'll see you guys here tomorrow. Thank you very much. Have a good night. Peace. Thank you to all the moderators that came out. You guys are awesome. Thank you very much to everyone that hit the like button. If you are new to our community, hit the subscribe button. Hit the notification bell right next to it. And we hope to see you here tomorrow for more coverage on the President Donald Trump administration, the Senate hearings, and everything in between. Thank you very much, everyone. Peace.